from the Cedar Grove Academy, which is in St. Catherine. When people hear Cedar Grove, they automatically think of St. Thomas. But Cedar Grove Academy is in St. Catherine. Could I ask the kids just to stand quickly for us? Just want to welcome you here today and hope that you enjoy your experience, and just remind you that you're always welcome, and anytime you want to skull a day from school on Friday, tell your teachers that you want to come back here, okay? So I hope you enjoy your stay here. And Captain Blake's son is a graduate from Cedar Grove Academy, and he was the head boy there, I think, about 2 years ago, and he's presently at law school. So hope you all continue to apply yourself and do well with your schools, with your classes. Thank you very much. Teachers, would you just stand for me, please? Students, you can sit. Teachers, thank you very much for thinking about bringing bringing the kids here for us today. We certainly appreciate it, and as I indicated to the kids, always welcome, and trust that you will enjoy and find the time that you spend with us today useful. You're always welcome to come back. The clerk and her staff are here for tours and all of that. So if you come again, as I said, you're always welcome. Thank you very much for coming and spending your time. Yes, but thank you very much, teachers. I'd said that about the persons being let in, but there's some technical. And there's a Mr. Samal D'Souza. Is he here, Mr. D'Souza? Now, this is a very interesting individual because Mr. D'Souza works with civil aviation in India. He has an interest in politics and democracy, and was just passing and asked permission to come in and spend some time with us. So, welcome to Jamaica, and welcome to the Parliament of Jamaica. Thank you very much, members. Statements by ministers. Announcements.
Laid on the table of the House today are the following: Ministry Paper number 35 of 2023, entitled Annual Report of the All Island Jamaica Cane Farmers Association for the year ended September 30, 2018. Annual Report on Audited Financial Statements of the All Island Jamaica Cane Farmers Association for the year ended September 30, 2018. Green Paper number 2 of 2020, entitled The Government of Jamaica National Natural Disaster Risk Financing Policy. Annual Report of the Universal Service Fund for the financial year 2021-2022. Annual Report for the Scientific Research Council for the financial year 2021-2022. Performance Audit Report on the Management of Fire Prevention Activities for the Jamaica Fire Brigade. The Auditor General's Department Audit of the Effectiveness of Jamaica's Institutional Framework in Establishing a Strong and Resilient National Public Health System. And the Road Traffic License Duties Amendment Order 2023 and its resolution.
Thank you, Madam. Bills brought from the Honorable House of Representatives.
The following is a message from the Speaker of the House of Representatives. To the Honorable Senate, I have the honor to advise the Honorable Senate that on the 28th day of March 2023, the following bills were passed in the House of Representatives: an act to amend the Electronic Transaction Act and to provide for connected matters, an act to amend the Companies Act and for connected matters, and an act to amend the Financial Administration and Audit Act and to provide for connected matters. Signed, Marisa Dalrymple Philibert, CDMP, Speaker of the House of Representatives.
Mr. President, I signify my willingness to take charge of the bills entitled An Act to Amend the Companies Act and for Connected Matters and an Act to amend the Financial Administration and Audit Act and to provide for connected matters.
Thank you, Minister.
Mr. President, I beg to give notice of the reading of the second reading of both bills. No?
Mr. President, I signify...
I recognize you from a seat other than your own. Thank you.
Thank you, Mr. President. Mr. President, I signify my willingness to take charge of the bill, an act to amend the Electronic Transaction Act and provide for connected matters.
A bill shortly entitled the Companies Amendment Act 2023, read a first time, and the bill shortly entitled the Electronic Transaction Amendment Act 2023, read a first time. Also, a bill entitled the Financial Administration and Audit Amendment Act 2023, read a first time.
Mr. President, I beg to give notice of the second reading of the bills entitled An Act to Amend the Financial Administration and Audit Act and to provide for connected matters and an Act to amend the Companies Act and for connected matters. I further beg to give notice that at a later stage today I will move for the suspension of standing orders to enable me to take both bills through all their stages.
Thank you, Minister. Petitions?
Stop.
Sorry.
Mr. President, I beg to give notice of the second reading of the bill entitled An Act to Amend the Electronic Transactions Act and provide for connected matters. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take the second reading of the bill and to take it through all its concluding stages.
Thank you very much, Minister. Petitions, papers, reports from committees, notices of motions given orally, questions and answers to questions, motions that may be made at the commencement of public business requiring notice. Who was sleeping, me? Or you, Ms. Lowe? The question is that notices of motions given orally be recommitted. Those in favor? Thank you, Minister.
Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motion. The Road Traffic License Duties Amendment Order 2023 Resolution. Whereas Section 18 of the Road Traffic Act, hereinafter referred to as the Act, provides that the Minister responsible for finance may, after consultation with the Minister responsible for transport, by order, revoke, increase, reduce, or alter any license duty specified in the third schedule. And whereas by virtue of Section 18.2 of the Act, an order made under Section 18.1 of the Act shall be subject to affirmative resolution. And whereas on the 21st day of March 2023, the Minister made the Road Traffic License Duties Order 2023, and whereas it is desirable that the Road Traffic License Duties Amendment Order 2023 be affirmed, now therefore be it resolved by this Honourable House as follows. 1. This resolution may be cited as the Road Traffic License Duties Amendment Order 2023 Resolution. 2. The Road Traffic License Duties Amendment Order 2023 laid on the table of the Senate on this 31st day of March 2023 is hereby affirmed. Mr. President, I further beg to give notice that at a later stage today I will move for standing orders to be suspended to enable me to take this motion.
Thank you, Minister. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without leave of the Senate first obtained. Public business. Just before you start, Minister, inquiring if there's any progress with Senator Morris and Crawford. On the platform, no. And the other observation I make before you start, Minister, is that for the first time that I can recall, Senator Brown is outnumbered by the fairer sex. So we expect to see some modification of his. Senator, Minister, you just indicate to me how you intend to proceed today, please.
Intended to, Mr. President. Thank you very much. It is intended to first take the Companies Act, the Companies Amendment Act, and then to proceed immediately thereafter to the Financial Administration and Audit Amendment Act, and thereafter the Electronic Transaction Act, and thereafter the order. If it is that the order is, however, going to be a matter of formality, we could take it before electronic transaction, which may actually have more debate. So, but that is the expected order. Thank you, Mr. President. Yes, thank you. Yes, thank you. Thank you. Mr. President, I now move for suspension of the standing orders to enable me to take second reading of a bill shortly entitled the Companies Amendment Act 2023 and to take it through all its concluding stages.
Members should have heard the question. Those in favor? Against?
Thank you. Thank you very much, Mr. President. Mr. President, today I rise to open the debate on the Companies Amendment Act 2023 in circumstances which we readily acknowledge are less than optimal. We circulated this bill informally last week, of course, recognizing that the very tight timeline for its passage wouldn't allow us to table today and pass next week, as would be our normal approach to such matters in accordance with the standing orders. So knowing our circumstances, we did as best as we could, making sure that members on both sides received copies of the bill. Those who were present at the sitting last week, I believe, received in hard copy. I was ill and out, but others who were not present, myself included, of course, received it in digital form. So we ensured, of course, also that members on both sides were aware that we are seeking to meet a deadline which, regrettably, for which the consequences of failure for Jamaica are far too great to risk. I want to note, of course, also that while this bill is coming to Parliament on a tight timeline and that nothing can quite replace the reading and reviewing of a bill by lawyers, so that consultation on the wording of the bill, given its complexity, would have been a better approach, an optimal approach. I am, at least to an extent, comforted by the fact that there has been sensitization about the subject matter of the bill and the intention of the Companies Office and indeed the MIIC on passage of this bill regarding the beneficial ownership framework. We've had articles in the bar, newsletter, in the newspaper, and of course the General Legal Counsel has been having courses as part of its CLPD program, which have been sensitizing persons to the intended enhancements to the beneficial ownership framework. So again, while this does not replace review of legislation itself, there is some awareness in legal circles, and of course the framework actually revisits and builds on amendments which were included in 2017. I think many people, just because of the timeline and the length of the bill, felt that this was entirely new, but by way of reminder, the beneficial ownership framework was significantly enhanced in 2017, and it included requirements which to some extent are being, thank you so much, adjusted in this bill by way of a change in definition fundamentally to beneficial ownership, which streamlines and clarifies what it means. In fact, some of the deletions that have been taken out of the older bill were more confusing than the language that is here today, and therefore that some will view, I think, when they review in calmer moments, that they will see that the framework is actually being improved in several respects. That being said, we do have a commitment from the responsible minister to hear the views of the legal community in terms of questions they may have and areas where they believe that a better balance could possibly be found, that can be addressed subsequently, recognizing that on a balance of what we need to accomplish in respect of avoiding blacklisting, fundamentally, that it is important for us to pass this bill today. And I will do as best as I can, Mr. President, to explain what this bill seeks to do, and we're able, well, let us proceed. I want to just go back a bit into context by way of reminder, Mr. President, that in 2015, our anti-money laundering and combating the financing of terrorism framework was assessed by the CFATF. And the CFATF, we know, of course, is the Caribbean Financial Action Task Force, which was launched right here in Kingston in 1992 and is comprised of 24 states of the Caribbean, South and Central America, who all came together to decide that we would implement common measures to counter money laundering, to counter terrorism financing and proliferation financing in alignment with our ratifications of the UN conventions on measures to combat these very scourges. So these are matters in which we as a country believe. So yes, we are signed up to international obligations in this regard, but these are things in which we as a country believe. We believe that corporate structures should not be misused to launder money. Money laundering funds crime, organized crime at its worst and most flagrant levels. And we believe that those same systems also should not be misused to finance terrorism and the proliferation of terrorism. So these are things that we believe in as a country. So while we can get distracted by discussions regarding external standards and external commitments, the truth is that, and while it is, of course, that we must seek to ensure that we are legislating these matters in an effective and appropriate way, the fact is that we are seeking to achieve matters which are good for our development as a country. So the 2015 assessment, Mr. President, focused on both technical compliance and effectiveness. That is the extent to which we use our AML CFT framework to mitigate these risks, that is, again, money laundering and terrorism financing. And the resulting mutual evaluation report of 2017, based on the 2015 assessment, revealed that we had deficiencies in our operational, regulatory, and legal frameworks in respect of both effectiveness and technical compliance. So since then, we've been working through various review and assessment processes. We know our capacity issues are real. We know the constraints of our legislative processes and that these issues are complex. But furthermore, we all know that we have been affected by loss of time during the pandemic. I know members on both sides recall that we were referred to the FATF's heightened monitoring program and that we've been placed on the gray list. And it has been, in fact, the heightened approach of the FATF during these review processes that have taken us to where we are, which is significantly progressed against our action plan, but not where we need to be. It is that which brings us to this place today, Mr. President. So we are in imminent danger of being blacklisted by the FATF. And this is a status that would seriously affect our ability to do business. It would affect not only government, it would affect business, it would affect individuals. Because what it would do is change the level of risk that countries and businesses outside of Jamaica view doing business with Jamaica and Jamaicans. It would say that our systems are not sufficiently robust in terms of their prevention of anti-money laundering and the financing of terrorism, and therefore that they need to close down systems or implement countermeasures as against our systems, which would of course be unbearable. Imagine you're trying to use your credit card on Amazon or on another site in order to purchase something which you cannot obtain here, and being told that your credit card is not recognized because it is a Jamaican credit card. That is the level to which we would be placing our country at risk. So it's important what it is that we're seeking to do today. The intention today is to pass a bill which will address our current rating in relation to recommendation 24, which is a recommendation on transparency and beneficial ownership of legal persons, in which we are partially compliant, because remember, as I stated earlier, in 2017 we did amend the Companies Act to introduce the element of providing information regarding beneficial owners. But it was assessed and determined that those amendments did not go far enough, primarily due to the following deficiencies which we seek to address today. One, that not all legal persons are required to maintain current and accurate information on directors, shareholders, and beneficial owners. Two, there is no active monitoring conducted by competent authorities to ensure that basic beneficial ownership information is current for all legal persons and arrangements, so that competent authorities now cannot be certain that the information provided, even though that requirement is there, they can't be certain that the information is accurate and up to date. And three, there are no appropriate provisions to ensure that effective, proportionate, and dissuasive sanctions are applied against companies who do not comply with the filing and record-keeping requirements or obligations to update beneficial ownership information. So again, the requirements are there, but they have no guardrails and no penalties to ensure that they are enforced. Mr. President, passage of the amendments will seek to address these matters, and they will, in so doing, address 3 of the 4 remaining actions on Jamaica's action plan agreed with the FATF. The 4 is in relation to risk-based assessments with the KYC and other requirements, which are matters in progress and also supported by the fact that the recent poker ruling by the Privy Council helps us to address treatment of these issues by lawyers as well. Mr. President, the bill therefore seeks to in summary, ensure that the provisions of the Companies Act, 1, conforms with the FATF standards relating to beneficial ownership of companies. So beneficial ownership is defined now in the Companies Act pursuant to the 2017 amendment. But the definition has changed, the threshold has changed, of control has changed from 50% ownership to 25% ownership. So it does have a wider scope, and there are some other adjustments which we will speak to more specifically as we go through. It will empower the registrar of companies with regulatory oversight to verify beneficial ownership for companies. So it's not only just what you say, it is that they will have the power of the law to verify what it is that you say. It will provide for mutual exchange of information between the registrar and competent authorities and law enforcement authorities, including foreign authorities. And this, of course, because of how it is that some of the structures, how these corporate structures are established, including both local and foreign ownership. And 4, it will provide effective and proportionate sanctions to deter non-compliance by companies in relation to their obligations to declare beneficial owners. I think it's important that we note that as we're looking beyond the technical compliance to effectiveness, that the Companies Office of Jamaica, working towards readiness for this bill, has established a new money laundering unit. So there's a new unit tasked with addressing these issues and to ensure that there is implementation capacity. I know that question was raised in another place. And it has also undertaken a significant ICT infrastructure upgrade, again, to provide greater efficiencies and capacity to address these matters, a lot of which can now be done electronically. So some of the things which used to be done before in order to speed up incorporation, etc., like establishing shelf companies and that type of thing, are less necessary now, because the time to incorporate, the time to establish a company, I believe it's one of the areas in which Jamaica is highest in terms of our doing business ratings. So some of the circumstances have changed since we first started to look at these issues. We've improved how we do business, and accordingly, some of the fears that we have, I think, about these circumstances will be addressed as we, for want of a better phrase, eat the pudding. So if I could just go through the bill now, Mr. President, taking us clause by clause. So clause 1, of course, provides a short title and directs that this act should be read in conjunction with the Companies Act and all amendments thereto. And we know that there have been significant amendments. We had 2017, we had, I believe, 2020, we had SIP, consequential amendments under SIP, we had consequential amendments under the Insolvency Act. We have been amending the Companies Act framework without Joint Select Committee and with, well, within the normal course of the legislative process. And this is, therefore, one more leg of that race. Mr. President, clause 2, which is the interpretation section, inserts the meaning to be assigned to new key terms used throughout the bill and revises the meanings of certain existing terms. So these example, beneficial owner, the most fundamental one, it's revised for consistency with international standards, as I said, reducing the voting share threshold to 25%, and more by the ability to control the company, and reflects that ownership can be established through a chain of ownership by indirect control. And I think what we'll see is by the removal of paragraphs 7, 8, and 9, subsection 7, 8, and 9, in section 2, we'll see that some of the more complex language about what is a group and how is a group structured, and what's a subsidiary and holding company, if one is A and X and Y, that language is being removed. And what we have now is a clear description of what is, for example, a chain of ownership and what is a beneficial ownership return, so that we're better able to understand that really the aim of this legislation is to ensure that you're always able to identify who is the natural person that actually owns a company or asset. And again, this is not intended to, you know, sort of prejudice a lady who may wish to secure her assets in a particular way so that her spouse may not have access to same. It is to ensure that where it is, that a structure is being used to hide, illicit goods or money that's being used for terrorist financing, that the person who is at the helm of that criminal enterprise, that they can be identified. And one of the things we'll discuss a little later is how it is that no beneficial ownership, I'm sorry, but I really have to laugh. Mr. Campbell is most offended by my example. But right now, under the 2017 regime, beneficial ownership information is actually public. But there has been a ruling by the European Court of Justice that says that it shouldn't be, that is an overstep, that it is something that, that as an international standard, as a FATF standard, is excessive, because it should really only be accessible by the competent authorities and the people who need to be investigating that beneficial ownership. So what we have done is that this bill actually reflects that adjustment and makes it so that the beneficial ownership return information that's provided now is not, will not be available to the public. It will be available on the consent of the beneficial owner, or it will be available, of course, by the investigative measures of the competent authorities, which will have their own guardrails for those processes. So that's, I believe, a better balance that's being introduced by this law. So, of course, competent authority, defined, designated authority, defined here. The competent authorities will be those bodies who hold similar regulatory bodies overseas to ours, to our Companies Act, to our FSC, to our FID, to our MOCA, those foreign authorities who can be used to verify information to which we would not have access if we're seeking to identify information that's, or verify rather, information that's been provided here. Clause 3 provides for the requirements for forming an incorporated company. And this section is being amended by inserting a new paragraph at subsection 1A to provide that a return of beneficial ownership containing accurate, adequate, and up-to-date information on each member and beneficial owner must also be filed with the Registrar of Companies. So it is largely the same process with an additional return which has this additional information in it. So again, some of that information is already provided for under the 2017 amendments, but this strengthens the clarity around what is required, an active requirement for submission of this return. Clause 4 inserts a new section 23A into the Act, and this speaks to the prohibition of nominee shareholders. And again, this is a question that has been raised generally. Why is it that this has been prohibited? But the fact is that nominee shareholders are not actually recognized by our current corporate legal system. You cannot register a nominee shareholder, no. This is just expressly stating the prohibition which is required for transparency in terms of FATF, but it is already not a matter that is generally included in our systems. And I recall hearing elsewhere where it was being said that this is changing things, people can't use shelf companies, etc. This used to be the process, but the truth is that when you had nominees before, by the time of your, for the purposes of shelf companies, by the time of your filing of the first return, you would have been, you'd have corrected, you'd have updated your return to have actual members, because any nominee you identified earlier would have not been for the purposes of actual holding. It would have just been to maintain for the period of time that you sought to speed up your incorporation. And now that incorporation takes place so quickly, that mechanism may be less useful than it may have been seen before. So in any event, you could never register a nominee shareholder. You couldn't do it now, so you won't be able to do it tomorrow. It's not a change. It is an express statement for the purposes of ensuring that this transparency is maintained and that that we do meet the standard that's being required. And this is the same thing in terms of directors, which is addressed later, but again, nominee directors not recognized in our system now. You can't register one, you can register an alternate director, that is somebody who acts in the event you're not able to act, but you don't actually, you can't actually register a nominee director now. It doesn't exist within our jurisprudence, within our corporate sector. So again, express change, but, and there are terms of art, again, there are terms of art generally understood within the sector and therefore not defined here. That is something people feel strongly about after in terms of review. Maybe it could be an enhancement, but it is actually not changing what exists now. Mr. President, Clause 5 amends Section 52 of the Principal Act. It provides for returns as to allotments, such as allotments of shares. And this section is being amended to include a requirement for all returns of allotments to be delivered to the registrar, along with an accurate, adequate, and up-to-date beneficial ownership return. So it's adding that matter of beneficial ownership return. And furthermore, this section is also being amended to require companies incorporated out of Jamaica and carrying on business here, so Part 10 companies, to deliver all returns of allotment accompanied by the certificate of incorporation or similar document evidencing incorporation, establishment, or formation of the company, which is to be certified in accordance with the Act. And again, this will facilitate greater transparency. Mr. President, Clause 6 amends Section 83 of the Principal Act, that section deals with the penalty for personation of shareholders. And here it is, the section is being amended by deleting the words "or of any share warrant of coupon," because the concept of share warrants has already been abolished. And we've also deleted the reference to being guilty of a felony and the penalty of hard labor, which have been replaced with a more modern language of committing an offense rather than a felony, and for a term not exceeding rather than hard labor, as that language is just more modern parts. But the offense itself, the fundamentals of the offense is not changed. Clause 7 amends Section 109 of the Principal Act, which deals with the register of members. So this again, this requires companies to keep a register of members, and that already exists. But the section is being amended to require that the register also include certain information on beneficial owners, and it specifies that that information is to be included in the register and mandates the company to notify the registrar of any changes in the information and the location within 14 days of such change. And the obligation to notify the registrar of changes in the membership of the company will not apply to public companies and companies limited by guarantee, because this clearly is not practical in one sense and not relevant in the other. So that will not be, that is not a problem. Registrar of changes will not apply to public companies. And of course, how it is that you now deal with initial membership in public companies, in IPOs, etc., none of those rules are changing. None of those rules are changed by this act. So that remains the same. Really, the issue is about changes in the register going forward. Mr. President, where an allotment is made of shares, or shares are transferred in the amount of 25% or more, and you'll recognize that threshold from the definition of beneficial shareholders, then the names of the allottees or the transferees shall not be entered in the register unless the listed particulars, including beneficial ownership information, are furnished to the company. So this is now what needs to be done when your traders or your persons who are selling shares, how they engage with a company. Unless it is that you're providing certain information, certain beneficial ownership information to the company, then that transfer should not be processed. It requires operating in a way, or rather the bill is making sure that on all sides the guardrails are set for ensuring that beneficial ownership information is furnished. And the section, of course, also creates offenses for breaches of the provisions in this section. Clause 8 amends Section 110 of the Principal Act, which deals with the index of members. And this section, which of course is likely to relate more to public companies, requires that companies with more than 50 members keep an index of members of the company. It's not quite the same, and it remains. The section is being amended by requiring, the company to also keep an index of the names of beneficial owners. So it really just adds that element to what exists. Mr. President, Clause 9 amends Section 112 of the Principal Act, which deals with inspection of the register and index. And this section is being amended by increasing the fine for the offense for the refusal by a company to allow inspection of the register by members. So remember, generally in company law, members can ask to look at the register. This section is saying that if a company refuses to allow inspection, then it is increasing the fine from up to $50,000 to up to $1 million, because the thinking is, if this company is being used to hide a criminal, or to hide criminal conduct, and one of the ways in which you protect that criminal conduct is to prevent access, which would otherwise be legitimate, then it is increasing the fine to disincentivize it. And again, it's not a fine of $1 million, it's a fine of up to $1 million, depending on, of course, the egregious nature of the circumstances or lack thereof. Clause 10, Mr. President, amends Section 113 of the Principal Act. It deals with consequences of failure to comply with the requirements as to the register owing to the agent's default. This section is being deleted and replaced with a new Section 13, which provides that if the register of members is kept by an agent of the company, so of course this is where you hire a company to deal with your register, etc. You're not doing those things in-house. But because of the default of that agent, the company fails to comply with the requirements under 109.3, 110.3, 112.1, or 113A, 1, 2, or 3, and these, of course, are all the beneficial ownership requirements, submission of the return, etc., then the agent will be liable to the same penalties as if you were a member of the company. So we note that, of course, the register will now contain information on the beneficial ownership, etc. Oh, sorry, no, I don't need to read that part already. I dealt with it already. I'd made a note about sharing the developments in terms of the privacy of the register and the developments with the European Court. We don't need to go through that again. I'm sure everyone understood it well the first time. But again, these sections relate to requirements concerning access to the beneficial ownership information contained in the company's register of members. Clause 11 inserts new sections 113A, B, C, D, E, and F in the Principal Act. 113A deals with inspection of the register of members by the registrar this time. So the registrar or a person authorized by the registrar can inspect the register of members. They can request a copy of it or an extract of it on serving the relevant notice that's provided for under 113B to the company. And it also creates an offense for the refusal of the company to allow that inspection or to produce the copy or extract that has been requested. Additionally, the registrar may also apply to the court for an order for the immediate inspection in particular circumstances and to direct that the copies of documents requested be sent to the persons requesting them. So she can request it by notice or can go to the court, can request it by notice within a period of time or apply to the court for immediate access given particular circumstances. 113B speaks to the notice itself. It speaks to the requirement of a notice and a minimum of 7 days notice being provided in writing for the inspection to be provided. 113C speaks to entry to the company premises and production of documents. So entry to the company premises for access to the inspection which I spoke about earlier. And it also prevents and creates an offense for any person who willfully obstructs, hinders, or impedes the registrar or the person authorized by the registrar in the execution of duties, or if the person refuses to produce a document which they have a duty to produce. 113D provides for the certificate of inspection. That is, once the inspection has been done by the registrar, then it requires the registrar to issue a certificate to say that the company was inspected, and also the company must be advised of any information that was found to be inaccurate, inadequate, or not up to date, along with a stipulation that the company must rectify same within 30 days of that notice. The registrar excuse me, must also inform the company of the consequences of the act, under the act, for failure to rectify the said information. 113E deals with the actual rectification and creates the offense of the company failing to rectify inaccurate, inadequate, or outdated information in the register of members on receipt of the notice provided for in section 113D. 113F speaks to the registrar provides for the power of requesting information from the company, from any public entity, or any foreign state which carries out functions comparable to a public entity in that state or country in order to determine whether information in the company's register of members is accurate, adequate, or up to date. So again, as I said earlier, it's not just filing a document that says that this is what is. It is that now the registrar is having the power to request from parallel organizations. Certainly somebody tells you this company incorporated in this country, or this person who lives in this country is the owner. Normally we wouldn't have the means by which to request of the relevant authority in that country to verify that this is in fact so. No, there will be a power under this act where the registrar can so do. Clause 12 repeals and replaces 116 of the Principal Act, which deals with notices of trust. The section is being amended by deleting the current section 116 and replacing with a new section. Now, the new section is essentially 116 subsection 1 of the existing act. What is happening now is that we're deleting subsections 2, 3, 4, 5, and 6. But the requirement that where a company has any notice of any expressed, resulting, implied, or constructive trust, the company must enter particulars of the beneficial owner as specified in the register of members. That is actually 116.1 of the current law. It was introduced in 2017, so that has not changed. How it is that that is construed, given the general provisions in the Act regarding this aim to get to transparency and the ultimate natural person, that is what may change our understanding of the implications of this clause. Clause 13 inserts a new section 117 in the Principal Act. It states, it provides that the registrar may strike off a company for default in keeping of for default in keeping the register of members. So the section provides for the registrar to strike off a company where it has been convicted for failure to rectify its register of members and where the company continues to be in breach of that requirement. So the section also provides for the procedure to be followed by the registrar in striking off the company from the registrar of companies. So again, you may see, but you're going to strike off a company for an error in relation to its register. But if the register is the core of transparency and your ability to hide misuse, that is why the register has now taken on this additional importance, and its accuracy, adequacy, and its currency are all relevant facts to be considered now. Clause 14 amends Section 121 of the Principal Act, and this deals with the duty to deliver annual returns. So the section provides for the duty of a company to file annual returns as currently exists. But the section is being amended by deleting subsection 3 and replacing it with a new subsection 3, which clearly creates an offense for the failure to file the annual return and removing the concept of the continuing offense. So it's now not going to be an offense for every day that it occurs. That's not how it's going to be dealt with. It's an offense once it occurs, and then the fine is going to be, the appropriateness of the fine will be assessed by the court in the relevance of the circumstances to the other matters. Clause 15 amends Section 122 of the Principal Act, and this is in relation to annual returns to be made by a company having a share capital, and this section is being amended to remove the requirement for companies having a share capital to file information in relation to beneficial owners in the annual return, since the new Part 11A in the Act has been created to provide the details for filing the beneficial ownership information in a separate beneficial ownership return. So this is consistent, of course, with the revised approach in relation to disclosure of beneficial ownership, which is addressed actually below in Clause 19, which amends Section 352 of the Act. And I referred to it earlier. I think it's a very important provision and a very important balancing lever in terms of how this Act will manifest itself. Clause 16 amends Section 124 of the Principal Act. Again, these are general provisions in relation to the annual return, and this amendment is going to delete subsection 2 simply because the provision references Section 111, which was repealed in 2017. So this is just a correction. Clause 17 amends Section 172 of the Principal Act, and this deals with number of directors and secretary, and here it provides that to prohibit companies from appointing a nominee director, since this creates vulnerabilities in relation to transparency of the framework, and further, this also provides that it's an offense to do so. So again, nominee directors may be recognized in other jurisdictions, but they are not currently recognized by the Companies Office. So this doesn't actually change our current corporate legal framework, as I discussed earlier. Clause 18 amends Section 337 of the Principal Act, and this is a general clause in respect of the registrar's power to strike defunct companies off the register. And the company gives the power to strike from the register a company that has ceased to do business in Jamaica. It's not new. The section is being amended by addressing the means of service for notice under this section for an overseas company which operates business in Jamaica. So it's just allowing for electronic service of notices now. So it is, again, moving with the times of what exists. Clause 19 amends Section 352 of the Principal Act, which deals with inspection, production, evidence, and retention of documents kept by the registrar. It speaks to the public's access to documents held by the registrar on payment of the prescribed fee, and addresses again, in this context, how the fact that beneficial ownership is currently information that's available to the public by virtue of its inclusion in the annual return, which is a public document. But public access not only goes beyond what is required for R24, which we're seeking to, but we believe that it unnecessarily exposes information of high net worth individuals who have legitimate reasons for their holdings in particular structures. So again, it's proposed that this revised approach of the privacy of information on beneficial ownership as defined in the Act be preserved and disclosed only in relation to persons with specific purposes, or of course with the consent of the beneficial owner. In keeping with that policy, Mr. President, the section is being amended to provide that on a written request by a person desirous of inspecting any document containing beneficial ownership information, the beneficial ownership information in relation to any intended company, or former company cannot be disclosed to any such person by the registrar without the prior written consent of the beneficial owner. So the formal language to reflect what I explained earlier. So of course, again, can be disclosed to persons authorized, including a competent authority, an authority of a foreign state or country carrying out functions comparable to the competent authority, the designated authority, the DPP, Commissioner General of Taxes, or a procuring entity as defined by the Public Procurement Act. Without those, in particular, without the consent of the beneficial owner, obviously, because that is in an investigative capacity. Clause 20 addresses the insertion or provides for the insertion of new sections 352A and B in the Principal Act. 352A deals with the protection of the registrar and authorized officers, protecting the registrar and her officers from any suits, action, or prosecution instituted personally in relation to actions done in good faith in the execution of duties under the Act. And B deals with the duty of secrecy. All persons having official duties under the Act have an obligation to treat with such information as secret and confidential, and it creates an offense of all persons who communicate such information other than to persons authorized by law or for purposes other than for purposes provided for under this Act. Clause 21 deals with the amendment of 362 of the Principal Act. And Section 362 addresses companies to which Part 10 applies. So Part 10 companies are companies registered overseas and operating in Jamaica, which have particular provisions for them. Clause 22 repeals and replaces Section 363A of the Principal Act. Again, it speaks to the registrar of companies to be kept by companies incorporated outside of Jamaica. So even though you're incorporated outside of Jamaica, if you're doing business here, you do have to maintain a register of members. And the section is being amended to also require a register of directors and, of course, to include the beneficial ownership information. Sorry, I think the director's information is there already. It's the beneficial ownership information that's needed. Clause 23 inserts Section 363B in the Principal Act. This, again, deals with the prohibition of nominee directors and nominee shareholders. But again, now in the context of Part 10 companies. Clause 24 amends Section 365 of the Principal Act, and this deals with the accounts of companies carrying on business in the island, and this requires Part 10 companies to notify the registrar of any alteration in relation to their charter, of their directors, name and address of persons authorized to accept service on behalf of the company, and of course, in respect of any beneficial owner, the actual amendment is to delete the word any that arises before beneficial owners, because the point is now that they must identify all beneficial owners, and that is a requirement. So the only amendment there is actually the deletion of the word any. Clause 25 amends Section 369 of the Principal Act, which removes the company's name from the register, or deals with the removing of the company's name from register. And a marginal note here is being amended to state Part 10 company ceasing to have a place of business in Jamaica. Clause 26 inserts a new Section 369A in the Principal Act, which deals with the striking off of the name of a Part 10 company, and it provides for the registrar's power to strike off a company to which Part 10 applies, where there's a failure in relation to the filing of the beneficial ownership return. So again, it's just applying to Part 10 companies what is provided for in respect of domestic companies. Clause 27 amends Section 370 of the Principal Act, which deals with penalties. This one deals with general penalties for breaches of obligations under the Act. And the section is being amended to specify that this provision only applies where no specific penalty is provided in the respective section. So there are sections which create new offenses under this Act, and those all have specific penalties provided. Section 370 is now going to provide that for anything that doesn't have an offense specifically assigned, this will be how the penalties will be applied. Clause 28 inserts a new part 11A in the Principal Act, referred to earlier. Again, beneficial ownership now addresses beneficial ownership in respect of Part 10 companies. So it speaks to the obligations of the companies and the registrar in relation to the treatment of beneficial ownership information. More specifically, this part provides for the duty of companies to file a beneficial ownership return on incorporation, the delivery of a return of allotments on an annual, and the delivery of a return of allotments on an annual basis. Provides for the information to be filed on beneficial owners to include every beneficial owner of the company in relation to a chain of ownership. And the chain of ownership is one of those new defined terms that make it clear that at every level, quite simply, at every level of ownership, you have a company owning another company owning another company, you must trace right through to the natural person at the top, which is how you get through your chain of ownership to determine ultimate ownership. An offense is also created for the failure to file this return. The information that should be included in the beneficial ownership return is provided here, and the duty of the registrar to verify the accuracy of the information filed in the beneficial ownership return. It provides for the procedure to be applied by the registrar for striking off in the event of failure to file the ownership return, beneficial ownership return. The duty of the registrar to notify the company of an inadequate, or out-of-date beneficial ownership return, and the duty of the registrar to keep a register of beneficial owners of companies. Also provides for the power of the registrar to ensure adequacy, accuracy, and currency of the register of beneficial owners, and they must keep the register up to date, and the power of the registrar to enter the registered office of companies, or such other location where the register of members is kept for the purposes of inspection or examination. Also provides for the power of the registrar to cooperate with entities including competent authorities to carry out the functions given under the Act. The duty of companies to keep a record of actions taken in relation to the compliance with beneficial ownership requirements under the Act and the applicable offense. Duty of companies to obtain and verify beneficial ownership information. The duty of the members of the company to provide the company with beneficial ownership information. The duty of the beneficial owner to provide the company with their information, and the duty of the company to notify the registrar where there's a change in the beneficial ownership of the company, and the applicable offense for failure to do so. So they deal with the duty of the members, the duty of the beneficial owner themselves, the duty of the company, the duty of the registrar, all in respect of ensuring that correct information is provided.
The member's time having expired, may I ask that it be extended to allow her to complete her presentation?
Question is that the member's time having expired, that she be facilitated with sufficient time to complete the presentation. Those in favor?
Aye.
Those against? The ayes have it. Minister.
Thank you very much, Senator Scott Motley. Thank you, Mr. President. Clause 29 inserts a new section, 379A, in the Principal Act. And this provides for the duty of the registrar to certify in writing whether a company is at the date specified in good standing. Clause 30 amends Section 381, which deals with form of registers. It deals with the form in which registers are to be kept, and this also provides for an offense. It creates the offense of failure to take the necessary steps to prevent falsification of the register. So if you don't keep the register in a way, or if you keep it in a way that ensures that it can be or facilitates its being interfered with or falsified, then that is actually an offense. Clause 31 repeals and replaces Section 382, which is creates an offense of persons who willfully make a false statement in any return or other document specified in the 9th schedule. Clause 32 inserts a new 386A, which provides for a fixed penalty regime for the purposes of more efficiently enforcing fines for breaches under the Act rather than requiring a court process on every occasion. Clause 33 amends Section 387, which deals with the service of documents on company, and again, this provides for service of documents by electronic means. Clause 34 amends Section 390 of the Principal Act, which deals with records, and it provides that companies must keep documents for at least 7 years, and including in respect of membership and beneficial ownership information. Clause 35 inserts a new 390B of the Principal Act. And this section provides that companies that have been struck off, wound up, or dissolved must keep records of that company for at least 7 years, or a lesser period being not less than 5 years as may be prescribed from the dissolution of the company. And this section creates an offense for contravention of this section. Amendment of Section 392 is performed by Clause 36, which deals with the power to alter or add certain requirements. And this section is being amended to extend the power of the minister to amend the forms in both parts 2 and 3 of the 5th schedule, as new forms to capture beneficial ownership information have been proposed for inclusion. Clause 37 amends the 5th schedule of the Principal Act, and this deals with the contents required by Section 121(2) and the form of the annual return of a company having share capital, and this now, of course, adds the new forms in relation to beneficial ownership and membership information. Clause 38 amends the 9th schedule, which deals with the forms that are provided for under Section 382. The 9th schedule provides for sections under which a person will be liable for an offense if false information is willfully provided. So the schedule is being amended to include the following sections to which the offense would apply. Section 122, which deals with the annual return made by a company having a share capital. Section 377A, which deals with beneficial ownership return. 377W, dealing with notification of change in beneficial ownership information. And 377AC1, which deals with the requirement for a written answer to the registrar's question. Clause 39 deals with the amendment of enactments and construction, providing that amendments to the company's forms, rules 2005, and the company's rules in light of the amendments to this act. And I am pleased to say that we now recognize that the Memorandum of Objects and Reasons conclude the contents of this clause, and the memorandum stipulates the key objectives to which we spoke earlier. Mr. President, I thank you all for your patience and invite members of this honorable chamber to contribute on the act before us, the bill before us, and indeed ask that they support its passage. Thank you.
Senator Allen. Permission granted. Yeah. And she's showing versatility.
Thank you, Mr. President. Huh? You prefer this already? I'll get back to you. I'll get back to you on that, my friend. Yeah. Mr. President, today is a day, thank you. Today is a day of deadlines. March 31. It is the day that we all are required to make a certain submission, all of us in this place. So So if you haven't already, you have until 5 o'clock. Today is the day before. Today is also the day if some of us in here have to deal with a certain thing called GCT. Today is the day. Today is the day that we also deal with the amendments to the Companies Act, in addition to the Financial Administration and Audit Act and the Electronic Transmission Act, and another one, road traffic. So today is a very, very busy day. But we all signed up to do this work, and so we do the work on behalf of the people. So when I take a of being blacklisted. And since we are not here to cause Jamaica to be blacklisted, we are providing the support that is required. But that's not the only reason that we're doing it. We too are of the view that companies must be compliant. We must operate in an environment where we do what we're required to do. So we have no question about why we're here. It's only, I believe, the how. The how. Because, and the how that I speak of is, I take what I do seriously, and I know all of us take what we do seriously. And the minister did say that the company's office and the other entities are readying themselves and have been readying themselves for the changes. But as legislators, we have not been provided with the same sort of time to ready ourselves to, get it right. Because we have listed here 38 or 39 clauses, right? Amendments, 39. Plus we had some amendments from the House, from the other place. It's a lot. Largely grammatical, but some fundamental ones were in there in order that we not cause Jamaica to be blacklisted. So, like the Road Traffic Act some time ago, we are here again. I don't want to say that we are being asked to rubber stamp, because that could never be it. It's just that it could have been done in a different way. But we move on. So I want to point out something to Minister, and I'll tell a little story. And the reason I can tell the story is because it's my story. You see, when I saw this bill, I automatically assumed that it must be about certain companies and not all companies. And that, especially when I went through and saw some of the fines, I still am not clear. But it's apparent that all companies, no matter the size, would be subjected to the same possible fines and so on. So let me give you an example of a personal story. So because I'm a good director of a company that I'm in, and I'm speaking as a smaller company, not the size of my colleague across the way. So I'm a little fish in the pond.
Not 100 years old.
No, I'm not 100 years old. At least not yet. Well, I'm not really hearing me at all today. I was saying that my little company that I am a director of, not the same size as other companies that are, some of them 100 years old, that have the structures and the staffing and the resources, but we still comply. And so, as you know, annually, as companies, you're required, as in section 4, in clause 14, you're required to submit your returns. So I get a text message and an email from the company's office to say that I'm delinquent. So of course I'm frightened by this because we know the repercussions are great and that I'm delinquent. But because I know that I submit my submissions, I know I don't really have anything to worry about. I just have to prove that I submitted it. So the submission was for 2020, activities in 2020, therefore you submit it in 2021, as you know. And according to the records, Mr. President, of the company's office, and they visited me, by the way, they did not have on record my submission for 2020. And as such, 2021 and 2022, they say, could not be accommodated or submitted. So technically, I'm 3 years out. No fault of mine. I did my job. The good thing is that I had my records to prove, thank God. Because can you imagine if it was also... Yes, I was beginning up. Okay. In any event, the point I'm making is, I soon get to it. The point I'm making, Minister, is that I understand and appreciate that you've mentioned that the ICT upgrades in the company's office. But now that we are making further changes that have significant repercussions to companies of any size who are trying their best to comply and are doing everything to comply, we have to help them to comply. And as such, we can't make it too onerous, nor can we or should we give them insufficient time to make the amendments in their organization so that they can comply. So it is the timing and the hope that our systems or the systems within the company's office will in fact be able to accommodate the changes as they currently don't allow, because technically under section 14 or clause 14, what page is that now? Clause 14, my little company would be in contravention, not just 1 year, but possibly 3 years, and could face a fine not exceeding, but it could get up to $5 million, especially if I didn't have the proof. So my only hope is that as we make these amendments, that the requisite support and structures are in place in order to facilitate people complying. So we don't have, but we know things will happen. And so we have to ask, what recourse might there be for any appeal in the event of something like this? I don't see any mention here of an appeals process, but I would imagine that there must be. And I would like to, obviously, using my example, to be assured that the appeals process would allow me and others to address certain matters. I beg your pardon? Well, according to them, I did not file. So I'm assuming I have proof. The company's office, based on their advice to me, they have indicated that I'm delinquent. I did not file. The documentation subsequently showed that I filed, but the system did not recognize that there was filing for some reason. The algorithm wasn't working. No, and I'm saying it's good that I have proper records.
All right, Senator Allen and Senator.
Sorry, Mr. President.
I have facilitated you guys with crosstalk.
Sir, Mr. President.
Yes.
Sir, Mr. President.
And you know, when you get a message that says, avoid legal action from the company's office, you kind of get nervous. And I got a little nervous. But we move on. Right. So we have a situation where that we hope will be addressed. Now, Minister, you made mention of the effective and appropriate sanctions, that you're seeking to have effective and appropriate sanctions. So my question is, all companies, no matter size, SMEs, micro, because we're in the age or the space where we're trying to encourage businesses to be legit, we have, or legitimate, I shouldn't be using slang in this place, we have numerous amendments. It's not parliamentary. We have numerous forms that are being amended in order to address the changes, just about all of the forms. Annual returns, the registration of companies, all of these forms are being amended. It means that the company's office and their team and new and existing companies have to become familiar, because I would believe that the majority of companies out there, I know this, are good and decent people who are seeking to do what is right. So I am asking, what is the plan for companies like mine and all the others out there to be educated on these changes that will so fundamentally change how they will be doing business? Because this is going into effect, for all intents and purposes, tomorrow. So the question is there a grace period? Is there a period of getting to know, of a period of familiarization that companies could be afforded? Because we know all are well intended. Minister, you and I are at one when we say that, when you said there is a desire to prevent companies that use and create shells to hide nefarious activities. We want to rid ourselves of those types of entities. But if we could contemplate a period, I don't know, 3 months, a decent period to allow the adjustment to take place, not only for the company's office, and for the accountants who have to deal with this, and the lawyers who have to deal with this, everybody. That would be my ask of you. So Let me see how many pieces of paper I have here. One of the most critical pieces I can't find, with my pink ink. So ultimately, Minister, when we look at the Memorandum of Objects and Reasons, Mr. President, I keep saying Minister, we are in agreement that we must move with alacrity to ensure that Jamaica adheres to what we've agreed to do. But we also ask that going forward, we try to do it in a way that allows for greater dialogue, because we're not trying, but we want to get it right. And we ourselves must be comfortable with what we're putting out. And I know, and I assume, I trust that you will cause for that to happen. And we are in agreement, so we are supportive of this. It is my hope that we can contemplate the few recommendations, the 2 or 3 recommendations, and if we, whatever we must do to facilitate the public sector workers in the office of the company's office so that they can do their job because they want to do their job. I know that. I met with them to resolve my own issue. We have to provide the facility for them to do that. We are supportive and we've made our point. No long talking here, at least not from me. Thank you, Mr. President.
Thank you, Senator Allen. What's happening? Senator Webby?
Mr. President, I know that we're all anxious to get the bill passed as quickly as possible. So I have a very brief presentation, and I thought your presentation, Madam Senator Allen, was quite good in terms of the Companies Act, because at some subsidiaries at the company that I represent, the smaller ones, met a similar situation which we had to hurry up and fix very quickly. So the back office of the Companies Act or the Companies Register, we need to get that fixed as quickly as possible. But that's administrative. So Mr. President, I rise to support the bill shortly entitled Companies Amendment Act 2023. Mr. President, as was stated earlier, and very importantly, this bill is aimed at strengthening Jamaican laws to prevent the misuse of corporate vehicles and promote international exchange of information for tax compliance. Mr. President, I understand as a businessman the implications of non-compliance with FATF recommendations, which would include the alienation of our financial system from the global financial community and loss of business opportunities and their related revenues. Mr. President, what I would say is that the Jamaican economy is the strongest that I've seen it post-independence in terms of all the macroeconomic indicators. And we can speak about the stability of the foreign exchange rate, unemployment, and growth. So we should not at any time risk in any way the momentum and the great progress that we have made in terms of the economic recovery and where we are going with the Jamaican economy. Because in my opinion, and based on my research as a businessman, the best is yet to come for the Jamaican economy. So with that said, Mr. President, I support the passage of the bill. And I also want to recognize the work that has been done by the current administration. Since 2017, when the mutual evaluation report from the FATF was published, we have made significant strides to strengthen Jamaica's anti-money laundering, terrorist financing, and the proliferation financing regime. This administration has made significant strides. And I want to commend the government for their work that has been done in this regard. Mr. President, let me also say, and colleagues, that I appreciate that the Minister of Finance will accommodate further consultation for amendments to the Act. I appreciate it a lot, because I want to point out that issue of rushing bills through the parliamentary process has been happening for some time now. So Mr. President, so we have our Minister of Finance, and it was clearly stated by our Leader of the House, Senator Kamina Johnson, that we are willing, or the Minister of Finance is willing to revisit any amendments in the future. I think as providing that they don't impact FATF, should be clear. Should be clear. So, as the upper house, Mr. President, what we need to ensure that when we have Senator Golden Campbell, what we have amendments that we would like to recommend that would not impact FATF, we need to ensure that we follow that through with the Minister of Finance. That is our responsibility as the upper house. I want to come back to the issue of Senator Williams, of rushing bills. I remember very clearly, and I said this has been going on for decades. I've been in the Senate from 2007, but for decades, Senator Brown. And then I'm asking again, as I said it in 2017, that we undertake a review. We undertake a review of our compliance rate with international standards to determine in which areas we are lacking in terms of tracking. Thereafter, Senator Allen, concrete deadlines we should set concrete deadlines in terms of these bills that are coming up for international implementation. And we should allow for timely manner of research, consultation, and feedback. What I have in mind is that we set up some sort of a tracking mechanism, and with the latest in technology, you can have a database with timelines and the responsible minister. So we can access that database and say that FATF or whoever wants the bill to be passed by March 31st. So there's this tracking mechanism. And with technology today and database systems that we have, I think that should be straightforward. But this has been happening, to be honest with you, from 2007. It's decades since I've been here. And I really believe the time has come where we set up the system leader, where we can track these bills and we don't have to be rushing them. Because last night I was up pretty late trying to go through these bills, and it was a little bit challenging, so to speak. So, Mr. President, having said that, there is an area that I need to do some more research on, because it's something that I've been following in the US and the UK. Is this issue of a blind trust and the beneficial ownership and what is required for disclosure. So that's a follow-up for me in terms of any recommended amendments going forward. But it seems to be a gray area in terms of what should be disclosed if you have a blind trust in terms of transparency, especially by the parliamentarians. I leave it at that for now, but I'm going to be doing some more research to see how we can get that done. So having said that, colleagues and President, I believe that this is a step in the right direction. I know it is being rushed with FATF, but there are some good aspects of these amendments, and I believe that we should go ahead and approve the amendments. Thank you very much, Mr. President.
All right, thank you very much, Senator Webby. Senator Scott Motley.
Mr. President, I rise to make a very brief contribution to this debate. And I want to embrace what Senator Allen has said. The opposition, we here, all of us, I think I can speak with confidence for the government on this occasion. We are all conscious of the need to fight against money laundering. It doesn't just affect and impact the terrorism aspect of it. It doesn't just mean that dirty money comes into the system, but sometimes it affects the entire governance structure. Those of us who operate on the ground know that sometimes elections can be tilted by the amount of money which you have to spend. And we do know that even though we have passed legislation and with our best efforts, this money still comes into the system. We must make every effort. We must be united in our quest to keep dirty money out of our system. But sometimes I think, Mr. President, that what I see is that the good suffers for the bad. Because those of us who comply with the law, those of us who go through these rigorous requirements, are really the best of us. We have no intention to muddy the waters at all. We would never do one single solitary thing that would question the integrity of ourselves or the companies that we represent. Somehow, those who are carrying out their nefarious activities always manage to fly under the radar. And this is what disturbs me, because we have been in this house, we have been so concerned, we have passed legislation. I know the minister is particularly concerned about meeting these requirements so that we can come off gray list, black list, any list. But that Jamaica's integrity as a financial destination and as a country which observes its obligations is preserved. I know that. Yet you will see massive buildings going up all around the place. And the narrative on the ground, laundering. You will have companies, even companies on the stock exchange, where people say, laundered money. That's what they're doing, they're laundering. And my concern is, how do we really ensure that people do not get away with it? This is the obligation that I think we have. Not just passing the legislation, but ensuring that it's implemented in a way that brings transparency to the actions of the companies and individuals. And so, Mr. President, I am totally dismayed about us having to do this. And normally, we all would participate on every single matter. You know the tendency, when you're in opposition, you feel that you have to protect and you have to ensure that those other voices are heard. So all of us talk. On this occasion, we are very cognizant of the number of matters that we have to pass and the deadline which is upon us. It's not the first time. As Senator Webby says, when I came here in 2017 and I protested against some of the practices, I was told, but we used to do it for Mark all the time. Mark, referring to the then Minister of Justice. Well, we had IMF deadlines and we cooperated. I don't take comfort in that, Mr. President. I really don't. I don't believe that we can always be looking over our shoulder to justify what we do. As a society, we are progressing. That is why we are passing these laws, because we want to change and we want to take Jamaica forward. And part of it is that the legislation, since we know we have to pass it, we have worked on it, we have put infrastructure in place, we must have the opportunity to get it early so that we can do our work as a review chamber and ensure that when the legislation is approved by the Senate, people have confidence in it. And let me say, Mr. President, when the attorneys started bombarding me with the Trust and Corporate Services Providers Act, my original reaction, no, sir, we never passed that. No, we didn't pass that. In fact, I was in the presence of Senator Ransford Graham when I was protesting, and he said, but you got up and you were concerned about the delay, the fact that it was on the knife's edge, and you complained, and he was most unkind to me because he said I quarreled about it. And you know I would never quarrel. But this act, and I'm hoping that the minister will cause it to be reviewed, this is not what we could have intended. So that even if you are making a will for somebody, Mr. President, even if you are assisting in the disbursement of funds to beneficiaries after you have finished the estate, in fact, on filing the estate, you are also caught by this legislation, placing estate funds on deposit. In other words, every single thing you do in relation to a will or probate, you have to apply. You have to get, pardon me? Under the trust. You have to get a license fee of $350,000. The annual fee is $350,000, and you need indemnity insurance, which is 2.5 times your revenue. Now, Mr. President, if you have to buy insurance, indemnity insurance, as I do, as a very small firm, you will realize how much it pushes up your costs tremendously. It impacts you tremendously. And if I was not a conscious and law-abiding citizen, I would have just turned my back on it, because it is very stressful. Why do I raise it in this context? When you have a small company, and a small company is subject to sanctions of this nature, fines of $3 million and $5 million, to a big company, they might be able to make provision for it. For a small company, the company is done, dead. And in a context where the government is relying on small and medium-sized companies to be the drivers of their economic progress, this is clearly counterproductive. I don't know what approach one could take. If I had had time to discuss and wrestle with this bill, I might have been able to propose a reasonable solution which would meet the objectives of all persons. Because, Minister, I take note of what you said, that there will be a review, or could be a review, if the purposes of the legislation is not in fact impaired. I would have liked to have had the opportunity to have that input into the legislation. And I want to urge us. I make an exception for the FATF regulations, but requirements. But I'm saying that sometimes it is better to take your time diligently to ensure that when the legislation passes through the House, and in particular the Senate, it is good law. I frankly am not in favor of us saying, oh, we realize that we have made significant mistakes. We know that it's not good. We know we have to change it, and we'll change it later. I don't agree with that. So I make my protest known, as apparently I've done before. I am told, according to Ransford, and you know I deeply believe in him. I want to acknowledge the work of the technical team. I think they have done remarkable work in bringing this legislation here. And I know that there are persons who have to work with every joint select, every ministry, everyone, in order for us to be in a position where we can meet a legislative agenda which is ambitious, but which is necessary and vital for the proper functioning of our society. So, Mr. President, we're going to support it. We're going to support it because we recognize and appreciate the importance of it. We're just asking, Minister, if it's at all possible, give us some more time so that we can diligently apply ourselves to the task that we are here to do, if it pleases you.
Thank you, Senator Scott Motley. Minister.
Thank you very much, Mr. President, and I thank all colleagues who have contributed to this debate. I think I would want to make the point. That I wouldn't want my earlier interventions to be interpreted to say that I think this is a bad bill and that it will have to be changed. This is absolutely not at all what I'm saying. Significant work. Very good, just to be clear, for clarity, for the record. Yes, because the fact is it's complex. It's complex and people want to understand it. And I, as much as anyone else, respect our role as a review chamber. So when I say that in recognition of the magnitude of the importance of the work that we're doing and not a reflection on the quality of the work that has been presented to us at all. And I want to just add my voice in thanking the technical team who is present today. And they have been working at this because, remember, they've been working at this from 2017, you know. And when those amendments were made, it became an iterative process since then. We had the 2020 approach. There have been sensitizations. There's been CLPD courses, etc. And so what's before us, though, is complex, and there's no denying that. So where it is, having been approached by persons, lawyers and others, who have said, well, some of it is really just fear-based. We don't understand. And when we look at it together, it may well be that the issues are resolved, as has been part of even my own process, post-LegCom, in reviewing and realizing that that's something I may have had a concern with. It's actually not a concern. It's dealt with elsewhere, but it requires that review, and there's nothing that replaces that. So yes, Minister Hill gave that commitment, and we're holding him to that. But we also recognize that we are passing the bill today, and therefore it must be considered in the way and in the practical sense that Senator Allen raised earlier in terms of, well, all these new forms, etc. What do we expect? So as soon as the forms are gazetted, as soon as the bill is gazetted and the forms have been addressed, they will be online. They'll be online, including on the Companies Office. There will be in person, and there will be online courses. There is a basic YouTube video, but it's going to be enhanced to be a practical YouTube video to help explain to people on demand. And there's also something more specific that's being looked at in terms of some negotiations being undertaken with an online educational provider to allow for on-demand practical guidance for different stakeholders. So whether you're an accountant, whether you're a lawyer, whether you're a company secretary, the type of emphasis that will be needed in terms of your understanding of your duties under this. Those will be undertaken. And we're hopeful that that type of approach, including, of course, working with the GLC on the CLPD courses, will help the transition. In terms of company size, one thing that we can be assured of is that within the context of FATF is built in this concept of risk-based application, so that apart from just the basic recognition that in 90% of the companies it's going to be your simple structure, the beneficial owner is the very same person that appears on your annual return. The information does not require any further any further inspection, any further declarations, because it is what it is. The structure is that simple. And where there's no chain of ownership. Clearly, you're only reporting on that basic, simple, privately held company. So I think there's a recognition built in to the structure that there will be so much that will be required of you and no more. But I'm hopeful that the Companies Office, in their sensitization, will perhaps give greater consideration to a risk-based approach from the rules in terms of what is required of you. But we'll see how that goes. In terms of what is required under the Act, it does allow for a risk-based approach. In terms of recourse for where it is that there is a difficulty. So we know that the infrastructure has been enhanced, and therefore we're hopeful that there will be less occurrences such as you experience. But we know how things are. And so while we hope for the best, we are recognizing that the structure where there's an offense recognized is that there is a series of notices that takes place before there's any action, so that you are notified that there's an error. You say, oh, but no, there is no error. I have the documents here. So there is no offense, and I'm going to file the documents, and the matter is rectified. The issue is where you're notified and you don't do what you're supposed to do. You're notified again, you don't do what you're supposed to do. You're notified again, it's an offense, and you are liable then to prosecution. And this is where the fines come in, because then while it is, we're not saying if you're a small company, your fines only go up to X, and if you're a big company, your fines go up. We're saying that money laundering, CFT, etc., that all of that requires that our fine regime is a disincentive for its misuse. So the fines are up to 3 and up to 5. They're not 3 and 5. I know we have a way to speak in a very relaxed manner to say a $3 million fine. No, it's up to. So again, the risk-based approach will recognize if you're a small company with a small infraction, you are not expecting a $3 million fine. And if that were to occur, I imagine that you would have a case to bring in respect of manifest excessive use of administrative powers. So we anticipate a reasonable approach to these matters. I believe that those are, in terms of the fact that we have had to deal with too many bills coming on a tight timeline, and that has been for years. I've had it in opposition and I've had it as government, and what we have is a systemic issue and a capacity issue. So for me, it is not so much of an issue of looking over the shoulder or you did it too. I think when we say that, we have done this as well, it's in the spirit of recognizing that we have a problem, and we both have had to make concessions because there have been circumstances where the fact is that the consequence for Jamaica outweighs our concern about a particular issue. We have both had to deal with it. And so I think that finding systemic solutions, which I think whether they're use of technology or they are building of our resource base, the actual hands and brains to do the work, the number of people to do the work, is something that must be a priority. And we have had that discussion, even in the context of this bill, internally, and that is something about which the government will speak in due course. But it is something that, that we take very seriously because we recognize it. It happens too often. And that is, that means that there's something that needs to be dealt with in a holistic manner. It's not one minister, it's not one bill. It is the nature of our legislative process on all sides. I don't mean that within the legislature. But so be assured that we will have a look at that. So I think that is as far as we can go in the matters. I do hope that my opening presentation was sufficiently full to help to allay some of the concerns and answer some of the questions that the public may have had about the bill in its scope and the amount of change that it has implemented since 2017. Again, I thank everyone who contributed, and I thank the team who prepared us, not only for the work, but prepared us for our readiness to meet our all-important international deadline. And in that context, Mr. President, I ask that the debate be concluded and that the bill be read a second time.
Thank you, Minister. The question is that the bill be read a second time. Those in favor? Aye. Those against? The ayes have it.
A bill entitled An Act to Amend the Companies Act and for Connected Matters, read a second time.
Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. As was disclosed as was disclosed in the debate and the opening by the minister, there are 39 clauses, and we, based on agreement across the aisle, we can take them together. So that's good. Very well. So we have clauses 1 through to 39. Those in favor? Those against? The ayes have it. There's a schedule in clause 38. Those in favor? Those against? The ayes have it. I put the title and enacting clause. Those in favor? Those against? The ayes have it. The question is that I do report the bill as having passed committee stage without amendments. Those in favor? Those against? The ayes have it. I do report the bill as having passed committee stage without amendments.
Mr. President, might the bill be read a third time?
Question is that the bill be read a third time. Those in favor? Those against? The ayes have it.
A bill entitled An Act to Amend the Companies Act and for Connected Matters, read a third time and passed.
Mr. President, it's now intended to take the debate on the bill entitled the Financial Administration and Audit Amendment Act 2023. This bill seeks to amend the FAA Act by repealing Section 48C(1)(c). This section, Mr. President, forms part of the Fiscal Responsibility Framework, which was enacted through amendments to the FAA Act in 2010 with the objective of creating binding fiscal rules aimed at enhancing fiscal discipline and ensuring improvements in public financial management. Mr. President, recognizing that much has changed over the past 13 years, including that we had further amendments to this fiscal framework in 2014 and again in post-2016 and 2020. Mr. President, I'll just, by way of reminder, restate that we had 3 rules to start. The fiscal balance rule, to reduce the fiscal balance to nil by the end of the financial year by March 31, 2016. There was the debt rule, to reduce the total debt to 100% or less of the GDP by the end of financial year March 31, 2016. And the expenditure rule, to reduce the ratio of wages paid by the government as a proportion of GDP to 9% or less by the end of the financial year ending March 31, 2016. In 2014, 2 of those rules were changed. One, allowing for a fiscal balance formula within the fiscal balance rule, and the second, changing the debt to GDP rule from 100% by March 2016 to 60% by March 2026. And then in 2020, of course, during the pandemic, we did a further suspension. And thank you very much. Thank you. That the target date in 2020, because of the pandemic, we had a suspension that changed the target date to March 2028. But through all of these, Mr. President, the wage to GDP rule at 9% remain unchanged. In fact, that wage to GDP ratio It was missed at 2016, as I've just explained. And in 2019, its revised date, its next revised date, it was achieved, but by 0.1%, so 8.9% is what was achieved. And since then, it has been missed. It has been elusive, Mr. President. In the years leading up, of course, we had the pandemic, and then, of course, we had our GDP really did not rise in the way that one would have hoped during that period. Notwithstanding, however, Mr. President, we are proud that Jamaica has successfully weathered the pandemic without the reduction of public sector staff, without a reduction of wages. In fact, we have done the opposite. And the pace of our recovery and the current buoyancy of our economy reflect well on the soundness of the economic and pandemic management strategies. So furthermore, Mr. President, as pointed out by the Minister of Finance in that other place, our experience through the pandemic has really taught us a few lessons, including that the wage to GDP ratio does not necessarily or is not necessarily required to ensure the sustainability of fiscal operations or the achievement of the overarching debt objective, which is proceeding well. So we also note therefore importantly, and we also note importantly, Mr. President, that the rule came about in different circumstances under a different compensation system other than that which is currently being implemented, which is far more streamlined and efficient and therefore more effectively managed. Mr. President, in this context, the government is therefore now seeking to remove the wage to GDP fiscal rule from the fiscal responsibility framework, for which both administrations can take some pleasure in the success of its collective work, which has taken us to where we are today, Mr. President. And given that the remaining rules, I believe we are all agreed, are adequate to provide the restrictions on spending to ensure consistency with the legislated debt target and by extension sustainability of fiscal operations. In fact, I recall the leader of the opposition in the other place saying that he had actually thought from the very beginning that it actually wasn't a necessary element of the fiscal responsibility framework once he had a wider debt target. So, Mr. President, in that context, recognizing that from a policy perspective, we are on the same page, I just wish to point out the two clauses, Mr. President. Clause 1, given the short title and commencement, thank you very much. It addresses the preliminary issues name of the bill and points out that it should be read and construed with the principal act, the FAA, Financial Administration and Audit Act. And Clause 2 simply states that Section 48(1)(c) is repealed. 48(c)(1)(c) is repealed. The Memorandum of Objects and Reasons sets out the reasons for the repeal, Mr. President, which I have essentially enunciated in my opening. So, Mr. President, just to note that the government does not intend, with the passage of this bill, to return to the days of unsustainable spending at all. We are quite clear on the benefits of discipline as has been our conduct to date, and we're confident that the other guardrails which are in place are sufficient to keep the economic ship of Jamaica steady and sailing in the right direction. So, Mr. President, in that context, I now invite members of this Honourable Senate to support the passage of this bill.
Thank you, Minister. Senator Lambert Brown.
Thank you, Mr. President. No. Mr. President, this is a very short bill.
It signifies something, Senator Brown?
That it is short. It is interesting, Mr. President, that the Memorandum of Objects and Reasoning is multiple times the size of the bill. And I want to speak a little to the memo, but before that, Mr. President, I crave your indulgence. On the eve of the 50th anniversary of the 5-day, 40-hour work week, which is tomorrow, to thank my colleagues in the University and Allied Workers Union for the militancy in 1972 in demanding at the University of the West Indies that a 5-day, 40-hour work week be established. The government agreed, and it was established in 1st of April, 1973. And then for the public sector, established on the 15th of April, 1973. So it's an important anniversary. Didn't know I was going to be around 50 years after that struggle to celebrate it today. And I'm happy that the talk now is, let's move Senator Webber from 5 days to 4 days. And Senator Gale and I would be quick to say, but there are workers in Jamaica who are working 4 days. For example, at Naranda Backside, 4 days, 12 hours. For the time being, I'm going to come to that later, Ronnie. 4 days, 4 days, and some weeks, 3 days. So over the fortnight, you get the 80. And it shows that Jamaica workers are prepared to cooperate. So on this anniversary of the 50th, on this day, the 50th anniversary of the 5-day, 40-hour work week, I really want to praise those workers of the university for standing up in struggle. I want to acknowledge also some of the students from those days, some who participated and supported the workers, and some who now hold prominent position in the country. But I leave them to celebrate in their own way. I have no intention of calling any names of such prominent Jamaicans who was part of that progressive struggle. Mr. President, what this short bill does is to repeal the wage to GDP ratio of 9%, which is currently in breach and in the near future is expected to be in breach. It's a case of, instead of breaching the law, let's do away with the law. And I'm worried about that approach because while I'm not wedded to a 9%, and I'll come back to whether it's 9, 10, 14, 15, while I'm not wedded to a 9%, our country, given our recent history, need to have a guide, some guiding posts, which will allow us to work together, not to make the wage bill be bigger than it ought to be and endanger the economic progress of the country. You see, when you take the approach which says, if you're not complying with the law, then change the law, then it raises issue for me like, well, let me say, I recall in the 1980s, the courts ruled against the government in respect to a matter at the Jamaica School of Agriculture in Twickenham Park. And the government abolished the school to meet the law. You know, the law, if you change the school law, if you abolish the school, then you have to obey the law. So I'm worried about this situation where you don't like the law, be dual citizenship, you want to change it. And this government has shown that when it comes to the Constitution, it often runs contrary to the Constitution. Be it the Bail Act, be it the NIDS, be it Senate letters, be it SOE, be it Chief Justice and Probation, or be it what we saw this week, a permanent secretary being shifted to a created position, contrary to the Constitution. You're like Lot's wife, you keep looking back. I'm looking forward. So let me make it clear. I am worried about that approach, that the ends justify the means. So I don't like that approach that is being adopted. I prefer the approach which says, and I'm sure my friend Senator Webber will agree with me, let's grow the denominator. Let's grow the economy. And whether it is 9, 10, 15, 8, or 5, the size of the growth would help you to get a decent wages. Mr. President, the object on memo, as I said, has a lot of lessons in it. It says in part in the third paragraph, fiscal rules are amended in 2014, setting the debt to GDP ratio. Then I sat on that side. Then Mark Golden sat on that side and led and piloted this bill, the 2014 bill, to establish the 60% target of debt to GDP. Sometime when I hear today people talking about this 60%, you get the feeling that they were the fathers. That they claim.
I don't want you to take on like Lot wife now and start looking back, you know.
No, I'm not looking back. I am recognizing that at that time, Mark Jefferson Golden piloted in the Senate this amendment for the 60%. I remember, President, the efforts of former Prime Minister Portia Simpson Miller and Finance Minister Peter Phillips to establish this 60%. Not that we were happy with it, but it was a necessary part of balancing the books while we strive to balance the lives of our people. I remember when we did that, there were those who said then, all you do is pass the IMF test. Last week, Senator Crawford showed some of the statements people made then. But today I'm happy. I'm happy that all sides now sees the wisdom. All sides see the wisdom of the Portia Simpson, Peter Phillips government, which included Mark Jefferson Golden, in anchoring Jamaica in fiscal rules. And we just didn't anchor in fiscal rules. We did things to improve the lives of the people. So it's a very interesting history lesson when we hear people talking about the 60% of GDP and how some of you don't want to get there. We set the target. We lay the platform to get there. And we do not give up paternity of it. Mr. President, the JLP government in 2010, as the memo of objects and reason pointed out, instituted the 9% wage to GDP ratio, which meant that what the public sector workers could get was constrained in terms of benefit improvement, was constrained by that 9%. And yes, the government of Portia Simpson, Peter Phillips, including Mark Golden, who came in 2012, had to maintain that ratio because the economy we inherited was really in the doldrums. The IMF didn't want to deal with us, and we have heard from the then director of the IMF about the famous Christmas Eve visited by the Black Caucus delegation of the United States Congress. On that day, went to the IMF and argued that Jamaica should be given a chance. It is against those facts in the article in the memorandum of objects and reasons that Jamaica had to negotiate public sector wages. And I recall, as I mentioned last week, that in 2015, we signed an MOU with the government. In that MOU, which is here, and let me look and see who are the signatories to it. I believe the signatories page would show the Most Honorable Portia Simpson Miller, the Honorable Peter Phillips, Honorable Horace Daly, who was the Minister without portfolio in the Ministry of Finance and Planning, and the government side. On the union side, it has Eileen Davis White, it has O'Neill Grant, it has Lambert Brown. Let me see the next page. Page has now opened. It has a space at the top, unsigned. And it has Granville Valentine, Keith Comrie, Patrice St. Patrice. I won't say to you, my friend, who the space unsigned is, but this is the agreement now currently on the Ministry of Finance website. So if you take a look on the 2015 agreement, we will see who signed then, who signed after you pass electronic law, who signed then. But you know, President, clause 4 of that agreement spoke to some obligations that the partners to the agreement would wish to fulfill. And at 4.1, it speaks to the importance of growth. It says the partners agree that it remains imperative that in the national interest, all sectors must remain committed to the continued improvement in the state of the Jamaican economy. The unions chose the national interest. At 4.1 it said, positive and sustained GDP growth. While the economy has returned to growth, higher levels are required to spur employment, improve government revenues, and support the country's level of expenditure to improve the infrastructure outlay. Current projections are that the country will begin to record GDP growth in excess of 1.5 by 2016. At 4 of that agreement, it speaks to continued restraint. The government will, while adhering to the economic reform program, engage in activities to promote growth and improve the business environment, which will accelerate job creation and better wages for an efficient public sector. The unions chose the national interest then, and we continue as trade unions to support the need for the economy to grow. And if we grow the economy, then whatever the denominator is, a bigger base will lead to more money being available to the public sector workers. The 2015 agreement, Chairman, at clause 8 and page 5, spoke to a compensation review. This is the 2015 agreement. Partners agree that the government will conduct a compensation review which will establish relations between and among groups in the public and private sector. The compensation philosophy of the public service will be determined and the review is to be completed in the contract period 2015-2017. Many things happened since then, including a change of government in 2016. It has now taken us, well, let me just add one other thing of that 2015 agreement. In the 2015 agreement, there was an agreement to discuss and implement paternity leave. That's 2015. And I'm happy that the Minister of Finance has now taken the recommendations of the trade union, and since January of this year, the public sector workers are now enjoying paternity leave plus increased maternity leave. And you can applaud the minister for listening to the union and that. So these things that we get now are matters that the unions have been struggling for. It has taken us seven years to get to the review. And that 7 years, we now get to a point where we see the repeal of the 9%. And so the public sector workers are saying, you're not bound by the 9% anymore. And in any event, as Keith Duncan said, you are already exceeding the ratio. But these 7 years include paying Ernst & Young $1.8 million US. The review, the compensation review, has turned out not to be fair to a lot of workers. We saw the rumbling 2 days ago into yesterday by the JUTC bus crew. We see the agitation from the teachers. We heard firemen restive. I know the correctional services are restive. I know the postal service restive. And I know a lot of other workers in the country have demonstrated that they do not feel that the review has been fair. One of the problems, President, is that the way the alignment, the realignment has gone. Somebody currently at the top of the scale is now being pushed down to the 4th point on the scale. You have a case where somebody with 25 years as a teacher is getting less returns than a teacher who comes 2 years without the experience. So there's something unfair about the compensation review, which has been argued to be fair, equitable, and transparent. There are many workers in the country who have said this is not fair. One area, for example, Mr. President, is the unilateral cut by the government of increments to workers. Under previous arrangements, the workers always receive their annual increment. Even in the worst of times, wage restraints, the workers always get their annual increment. So with this 9% being removed, why are we removing the increment from the workers without agreement for the next 3 years? Why? And this is without the agreement of the unions. The Jamaica Confederation of Trade Union, at the end of January, wrote to the Ministry of Finance complaining that a number of issues, absorption of duty allowance, non-payment of increment for 22-25, cessation of passenger miles, cessation of payment for mileage arising from sessions or honorarium, cessation of walk foot traveling, have taken place without the unions agreeing. I can tell you that the agreement signed by Senator Gill did not include the removal of these benefits. Even though I didn't sign that agreement, I know there was no such agreement for removing them. And so, President, I wish to call upon the government of Jamaica to restore the increments to public sector workers which they have unilaterally removed. There is no document, there is no verbal agreement between the unions and the government. And I wish to alert the government that only on the 6th of March this year, that the Court of Appeal in a case against Fred Campbell, who worked with Justice, and the Attorney General, that the Court of Appeal cited in the final paragraph of its judgment the following case of Printing and Numerical Registering Company versus Samsung. It's been a strong man. It's an 1875 case, St. Abraham. And in that, Sir G. Jessel, Master of the Roll, stated, if there is one thing which more than another public policy requires, it is that men of full age and competent understanding shall have the utmost liberty of contracting, and that their contracts, when entered into freely and voluntarily, shall be held sacred and shall be enforced by the courts of justice. Therefore, it is paramount public policy to consider that you are not likely to interfere with the freedom of contract. Senator Gill, the public sector workers have contracted for those increments. No government badness, no government bullying can unilaterally remove those increments. And again, I call on the government to withdraw the Circular 20 and to restore to every public sector worker their annual increment. Mr. President, even in the bad times, as the 2015 agreement show, the Portia Simpson, Peter Phillips, Mark Golding government, because they were part of the cabinet, extended that benefit to temporary workers. So temporary workers for the 2015-2017 contract continue to receive increments. Why then is this government removing the increment from the workers? Mr. President, our side appreciate the key to paying public sector better is growing the economy. We appreciate that. A bigger economy, as I've said before, means that even 9%, Senator Webby, could be bigger than a 13% of a smaller economy. The key to watch is the size of the economy, not whether it's 9 or 13%. So the 13.8%, no, President, look big, but relatively It could be smaller than a 9%. I'd rather to be seeing our economy growing and we pay 9% than pay 13% of what is now. So with a flawed compensation system, we need to fix it. But the problem, President, is despite what my friend Senator Webber just said about the state of the economy being strong, I'm deeply worried about the prospect for growth as reported by the government. We have had promises of 5 in 4. So it was, John? 5 in 4? About these promises of 5 in 4. That 5 in 4 has bucked up on the reality, some will say of COVID, but also a structurally weak economy. Hence the proposals by opposition spokesperson on finance, Julian Robinson, for us to move from a low-wage, low-skill economy. Mr. President, the government puts out their projections for growth, and they put it out in a book called the Fiscal Policy Paper, which all of us in this chamber receive a copy. Can't say everybody read it, but in that book, the Minister of Finance said in part, I hereby attest to the reliability, accuracy, and completeness of the information contained in this fiscal policy paper and its compliance with fiscal responsibility principles signed by the Minister of Finance. In that document, President, dealing with the macroeconomic situation, it says in part, the pace of growth was weaker when compared with the corresponding quarters of the previous fiscal year, when the COVID-19 measures were progressively lifted. And I make that point because the government is saying going forward, the growth that you expect to get more salary from is looking weaker. In the fiscal policy paper, it says in part, the positive momentum in the construction sector during the previous fiscal year waned during the first and second quarter of the current fiscal year. The decline in construction, down 4%, was due to the contraction in other construction components, resulting from a reduction in the sales of construction-related inputs and lower capital expenditure and civil engineering projects activities. President, when I heard my friend Senator Samuda last week reel off a lot of things, I thought that that was going to be promoting big growth, not according to the government document. And when you want to hide something from people, put in a document, put in writing. And here is it in writing, not hidden from those who are discerning and who are prepared to read.
Yes, okay. Senator Brown.
Yes,
Senator, that is correct.
You're going to take 120? Or is it one?
It's not. I don't see two before the. I don't see two before the two. The speaker's time has expired.
Thank you, Mr. President. Noting the time, I'm hoping there can be a coincidence of two matters, and but I ask that the speaker's time be extended to allow him to complete.
Questions that the speaker's time be extended to allow him to complete his presentation. Those in favor? Those against? The ayes have it. Continue, Senator. Senator Brown. Pardon me?
President, that's the construction sector. And from my office, I can look out and see all these high-rise buildings. When I leave my office in the night, Senator B, I don't see no light turn on. Darkness. These buildings are not being occupied. And it tells a story. Not only construction is down, but mining and quarry declined by 47.5%. It's government book. And then the book continues on page 4. It says, the risks to the growth forecasts are skewed to the downside due to a slowdown of economic activities globally, ongoing inflationary pressures, and deepening of geopolitical tensions. In other words, the workers I represent, Senator Gale represents, are looking for growth. We have made a lot of sacrifice. We have heard the promises of 5 in 4, but that has not materialized. In fact, the book went further at page 13 to outline, page 13 of part 2, to outline the prospect for growth going forward. And this strong economy we're told about says that this year, 23-24, the expected growth is 1.6%. And this is before the drought, Senator Samuda. And if agriculture was a big booster in the past, agriculture will be affected by the drought. So that's 1.6 for this year. Next year, 24-25, 1.1% is projected. 25-26, 1%. 26-27, 1%. That's what the government is projecting in their book. Their book, which I say is accurate and reliable. So the days ahead for the growth of the economy seems dark. You know, Senator Scott Motley, there was a former Minister of Finance who once described growth rate like this Senator Webby as anemic. I wonder what Ardlishaw would say now about these growth numbers going forward for the next 4 years. So we're not going to get 5 in 4. We're getting 1. And these projections in the government book seems to signal the death of Project 5 in 4. We're not going to get that in the next 4 years. So the death of 5 in 4, and it seems to me that stating it in the fiscal policy paper, that the government has abandoned and buried as gimmick this so-called 5 in 4. So when I look in the other place and see the gimmicks, I don't pay too much attention to it. Because all the paper you may want to roll out, you haven't rolled back one of those taxes. Mr. President, the 5 in 4, which is necessary to pay workers more, is like this promise of sleep with your doors and windows open, not fulfilled. It's like the promise of fixed elections, not fulfilled. All of these gimmicks are really aimed at getting voters' attention and hopefully votes. But it reads so bad now, Mr. President, that the government has abandoned vote getting because you cancel the local government election. You postpone it. You're afraid to keep it. So the government is afraid to keep local government elections. Mr. President, the real way to fix the wage issue is not a mere repeal of the ratio through the laws. The real fix is increasing productivity, increasing growth, and above all, Senator Gill, providing respect and consultation with the workers. It's not about bullying of the public sector workers. It's not about telling them if you don't sign now, you can't get the money. It's about sitting down and dialoguing with them, getting their support. And that is the real way to deal with this wage issue, because the truth be told, our wages for public sector workers is still too low. If you talk about Singapore, they pride themselves on well-paid public sector. In Jamaica, our public sector workers are poorly paid, despite the fact that we exceed the 9% of GDP. So, Mr. President, the government needs to connect and listen to the workers. I say in closing, they need to listen, Senator Webby, because you always support the security force leaders. Listen, DCP Fitzbailey, when he says, don't distract the police. Treat with them properly. Give them reasonable increase. Either listen to the letter from Ellen Davis. Maybe take it, I'm just a minute. But yeah, all right. Listen to the letter from the Jamaica Confederation of Trade Unions about your unilateral imposition of a no increment policy. Listen to the Civil Service Association, who also wrote and has reported a dispute about the increment issue. Listen to them. Listen to the head of the JTA, who, like I, had the courage of her conviction not to sign something that she felt was best for her members. Listen to the voices. Listen to the voices of the JUTC workers, of the firefighters, correctional services, postal services, and other workers who are complaining about the unfairness of the compensation system. Fix it now that you're changing the law without any limits. I say this also, listen to the voice of those who are calling for an increase in the PAYE threshold. Because one of the things that this compensation review has done is to move a lot of workers into paying income tax and thereby making them worse off in a real sense. I don't even add inflation in. So I'm calling and supporting the need for an increase in the PAYE threshold from this vaunted 1.5. 1.5, too low. Mr. President, yeah, and I'm supporting her call. She's the president of the Jamaica Confederation of Trade Unions, of which I'm a vice president. I support the call. Mr. President, a man convinced against his will is of the same opinion still. And I come here to tell you that the public sector workers are not happy. Some may have signed, but they are not of a different will, that they deserve better. If the government doesn't fix it, that's the last sentence. You want to go? It's the last sentence. If the government doesn't fix it, as I have said, as opposition spokesperson on public service, we, the People's National Party, led by Mark Jefferson Golden will fix it for the public sector workers. May it please you, Mr. President.
Thank you very much, Senator Brown. Senator Gill? Oh, I'm sorry, of course. I know exactly what I'm doing. Senator Gill, I'm going to take the 120 and then get back to you. Minister, it's one.
Mr. President, might the Senate be permitted to sit beyond 1:30 to complete the business of the day?
You should have heard the question. Those in favor? Again, Senator Gill.
Thank you, President. You know, President, I listened to my trade union colleague, and there are some points he would have raised that I would have agreements on. The matter in relation to the increments for public sector workers is something that the Confederation of Trade Unions would have raised, would have discussed, and we have agreements on that. The move is not in favor of the public sector workers, because public sector workers thrive on the increments. Mr. President, Senator Brown in his presentation alluded in his mind that the government is changing a law because the government don't like the law. On the present trajectory, Mr. President, the law, if continued, would be an albatross. Well, I don't want to use the term shackle. One thing is clear, is that the government is not intending on abandoning the rules. And I am of the view that the mere fact, one of the things that we can agree on in this parliament is that when it comes to fiscal rules, both administrations have adhered to promoting fiscal rules. And with that being said, we have a legislation that would have become an albatross in its continuity. Why not remove the legislation but promote the rules themselves? We can easily coalesce around setting specific targets and working towards those targets. So we can set a number, we can set a figure, Senator Webby, and work towards that. And an easy medium to do that is that we have the construct of a social partnership, where the respective stakeholders can come together and agree in the pursuance of a policy aimed towards continuing these fiscal rules. So we don't have to have a law if we are disciplined enough as a country to pursue a particular target agenda. And that is what I'm promoting, Mr. President. President, public sector transformation is a very important medium to change our public sector, to make it better in providing service to our country. This compensation review that Senator Brown spoke about was one of the intended objectives in order to transform the public sector, to ensure that our public sector workers, we can retain and attract them and they are compensated better. I recall as far back as 2011, Mr. President, when Jamaica gave a commitment to reducing the public sector wage bill to the 9% of GDP. Because of the impact of the inflation, and some would have argued the implementation of the compensation review, wages to the ratio would be higher than what was currently envisaged to meet this legislative level. Mr. President, we're right. It requires a review, because on the existing trend, we would continue to breach that target. And we don't want to be in breach, Mr. President. The closest we would have gotten, is in the 2019-2020, when we achieved 9.2% of target. That's the closest we would have gotten. Mr. President, Senator Brown spoke of some periods to which you would have said that, according to him, great work was done in terms of the fiscal rules. But I recall in 2013, when we put into effect those fiscal rules, we were living with wage restraint. And after that, we had incremental movement in wages. And so public sector workers would have gone through a dark period of sacrifice. Mr. President, this compensation review has changed that, and public sector workers, in my mind, are at a better place. Mr. President, not only that, we have placed the economy in a better position with growth. Mr. President, if we were to have continued on the trajectory in promoting this 9% of GDP growth, what would happen is that we would be competing with our capital expenditure. You don't want to place yourself in an economy where you are going to have to be forced to use your capital expenditure for other purposes other than they were intended. Mr. President, what is important is that in pursuing the growth agenda, in pursuing the fiscal rules, we ought to try as best and as practicable as possible to manage inflation. And in managing inflation, we can ensure that the consumers and the labor force would be at a better place. We must also, Mr. President, continue our debt reduction to free up resources and create that fiscal space that we need. I want to suggest, Mr. President, that where we must go in this country is that we must develop and establish and promote a culture of productivity and performance. That's where we must go. That is where the debate should go as a country. So we must not come here. We must not come here and speak about the past and point fingers. We must talk about the future, and the future is in relation to productivity. Mr. President, today we are looking at a particular fiscal rules. Tomorrow I want to urge us to develop and promote a special action plan and program to improve and monitor productivity in the public sector. So we have moved now to trying to improve the compensation level for the workers in the public sector. And yes, look, we have never gone through an exercise of this nature. Never. And so there are going to be concerns raised based on the outcome with the varying groups and bargaining units that you have to treat with. What I would encourage is that the concerns that are raised, the concerns must have an ear that they can listen to. Yes. And the thing I know about this government is that this government is a government that listens to the working class. Yes, seriously. Mr. President, to improve performance in the public sector can only serve to better improve the support and service for the private sector. So if the public sector was in a position to improve its performance, improve the level of efficiency, reduce the waiting time and the bureaucracy, then we would be at a better place towards growth. That is where we should focus. That is where the discussion should take place. Not about gimmickry. Not about the gimmicks that Senator Brown spoke about. We must raise the level of the discussions now, and the discussions must be targeted around performance as a country, performance as a whole. Mr. President, under the existing legislation that we are repealing today, it is the same public sector worker whose pay is required to be in check. And it's the same public sector worker that we are demanding a greater degree of delivery. And so we must get to the stage where, having gone through the compensation review and place them in a better place, and if we can deal with the concerns that have been raised in relation to the offshoot of the outcome of the compensation review, then we must take it to another level where public sector workers can gain an incentive based on the outcome of performance. That's where we must take it. We must take it to a level where we can develop our public sector worker, train them more, provide the technological support to improve their efficiency, and then we can reward them greater for their performance. So we're moving away now from having this fiscal, no, I don't deal with gimmickry. That's one thing about me. I don't deal with gimmickry. No. Yeah. Yeah. And I'm coming to that. Because you would have indicated that we don't move any, we don't, with all this paper we roll out, we don't remove back no tax. When we reduce GCT to make disposable income greater for persons, what was that? When we create the minimum business tax and we remove it, what? Yeah, we removed it. What was that? Look. We reduced property tax. We transfer tax. And there can be a, but guess what? You never know them, you never understand them, and the fact of the matter that you couldn't do them and we did them. And what we did was to make Jamaica in a better place. So one of the things, President, is that if you, so when we created the 1.5, it was more to create disposable income for a group of workers. And a group of workers would have benefited from that. There is no argument about that. But if you have a threshold in place and you continue to increase the earnings and the wages for workers, it is going to put a hamper on that threshold. It's same the ones who are at the 30 million mark. Yeah? The 30%, sorry. 30%. Once their salary increases to a particular level, even if it's $1 it increase to put them over the threshold, it is going to expose them. What I heard the Minister of Finance would have indicated, that yes, he's mindful of it and it's likely for a review. But, you know, we must not come here and behave as if nothing was done for the country. Because in the last few years, most things have been done for the benefit of this country more than decades ago. And look, whilst this administration continues to be in government, we're going to continue to do it. And so, Mr. President, yes, we are repealing this rule that I consider to be an albatross. But I want us to focus on how, as a country, we can collaborate around having some performance targets, monitor those intended targets, and continue to achieve them for the benefit of this country. May it please you, Mr. President.
Thank you very much, Minister. I just made an assumption, I'm sorry.
Oh, fantastic. I wish I had a few more. No, seriously, no. We appreciate it very much. No, this is fine. Thank you. Thank you very much, Mr. President. And as we continue what is undoubtedly an excellent day of cooperation in this chamber, it is we are trying to be as productive and efficient as we can be. Several issues have been raised, and I want to just say that I wholeheartedly endorse and I very much appreciate the presentation made by Senator Gale just now, making it clear that the massive and transformational approach that has been taken to public sector compensation by way of the compensation review. I mean, I don't think in our history, in the history of Jamaica, this type of change has not been undertaken. It's been a massive undertaking. So you must have some wrinkles that will have to be ironed out. And the minister has given his commitment to continue to review that. He has given it to the workers, he has given it to the unions, and that much is clear. But it is indisputable that as a whole, the public sector has been put in a better position. And it is indisputable that as a country that has suffered and that needs to grow to the extent that we do need to have a conversation about productivity. That is where the next level of focus is needed. I want to also say that one of the things that I know we've experienced, and in my ministry it's been particularly, I've been crystal clear on it, is that the workers at the lowest end have had significant increase on this. So while I understand that there may be concerns by workers at the upper and middle end, that people feel that they expected more at the lower end, they have been brought up significantly, and this is something of which this administration can be very proud. And it's something that I've been very pleased to see, because it's hard, very hard. And I want to also say that what is clear is that over the next 2 years, there will be increases that will move to the desired level of compensation. That has already been agreed. So you want to have a prior conversation, and that is probably an ongoing discussion, so far as I understand, But what is already built into the review is a continued increase over the next 2 years that has been agreed. So I wouldn't want us to leave here with an impression that we are not seeking to do as best as can be done in the context of taking Jamaica to where we need while achieving the appropriate balance. Because as we were at pains to say recently, while we are doing very well in terms of economic recovery, our recovery is fragile and we are not where we want to be. We have said that 1,000 times over, but we're working at it and we're committed to recognizing that is a delicate walk. It is a strategic balance, and productivity is absolutely going to have to be a major part of that. Again, removing this wage to GDP ratio comes in a context where we have set up an independent fiscal council that will manage our fiscal reform and our fiscal discipline independently. That is going to be a new phase of how we operate. So again, the requirement for this particular one, and one which, you know, we have absolutely overshot with the compensation review and the increases that have been offered. So I want to say that we are moving into this new phase, confident that better will come. But we all have to work together, labor and capital, public and private sector. All of us have to work together to make this happen. So I won't go much further because we do have more work to do today, and having agreed that we are intending to proceed today with the repeal of 48 big C, 1 little c, I want to simply thank members for their continued commitment to ensuring that we all do our part in making Jamaica the place to live, work, and do business. That I will ask for second reading of the bill, Mr. President.
Thank you very much, Minister. The question is that the bill be read for a second time. Those in favor? Against?
A bill entitled An Act to Amend the Financial Administration and Audit Act and to provide for connected matters, read a second time.
Thank you, Madam Clerk. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. Thank you. Members, I put clauses 1 and 2. Those in favor? Against? Ayes have it. I put the title and enacting clause. Those in favor? Against? Ayes have it. The question is that I do report the bill as having passed committee stage without amendment. Those in favor? Against? Ayes have it. I do report the bill as having passed committee stage without amendment. Minister?
Mr. President, might I ask for third reading of the bill?
Members would have heard the question. Those in favor? Against?
A bill entitled An Act to Amend the Financial Administration and Audit Act and to provide for connected matters, read a third time and passed.
Thank you very much to members of both sides for their contributions and cooperation in this matter. Minister?
Mr. President, might I ask for the suspension of standing orders to allow me to take the motion, notice of which I gave earlier?
Members should have heard that question. Those in favor? Against? Proceed, Minister, please.
Thank you, Mr. President. Mr. President, today we intend to proceed with the Road Traffic License Duties Order 2023 and the resolution which brings it here, the Road Traffic License Duties Order 2023 resolution. This order, Mr. President, is about the removal or lowering of costs related to the importation and usage of battery electric vehicles, and specifically pickups and panel vans. So in that other place, an order was passed which allowed for the customs duties to be lifted, and the accompanying order which allows to expand the license duties reduction to panel vans and pickups. That, however, requires affirmative resolution, so that one has come to us to accompany and implement that change in full. Mr. President, the IDB has supported a program of review on the matter of ensuring that we increase or facilitate increased uptake of the use of electric vehicles. And part of that has been a recognition, a database recognition, that reduction in the customs duties and the license duties are likely to result in an increased uptake. So, Mr. President, in July last year, the government provided some fiscal benefits for battery electric motor vehicles, motor cars and SUVs. And in so doing, the import duty rates in particular were reduced to 10% from their previous rate of 30%. And the requirement for payment of annual license fees on these vehicles, that is motor cars and SUVs, was also removed. This order will make that incentive, that is the move from 30% down to 10%, and the removal of license fees, annual license fees, also apply to qualifying pickups and panel vans. So the intention, of course, is to send a strong signal to the general public that we are committed to ensuring that by 2030, a significant portion of motor vehicles, that is our fleet in Jamaica, should be battery electric vehicles. In that context, Mr. President, yes, it is important. There are benefits. I'm sure Minister Samuda is going to hold himself back from giving us a 2-hour exposition on why it is important for us to have more electric vehicles than to continue with fossil fuel reliance. But he's going to hold back on that today and share it with us another time. And we will be so grateful to hear it then. Yes, we'll be grateful to hear it then. So, Mr. President, essentially in the order, Clause 1 states the name of the order, and the resolution sets out what is being required. Clause 2 deletes the words motor car and substitutes motor vehicle, which can then be interpreted within the relevant legislative framework, and accordingly have the benefits which we anticipate. In that context, Mr. President, I ask this House or this chamber to affirm the Road Traffic License Duties Order 2023 and the Road Traffic License Duties Order Resolution, which has brought it here.
That's if there's no other contribution.
My apologies. I asked for it to be done, but I'm open to hearing other comments on it.
I don't take it personally, Minister. I really understand, and I only stand to lend my support and to say that the country is cognizant of the need to move forward in this particular area. And as you said, lifting the duties, reducing the duties will be an incentive. However, I would like to be assured that at the same time we are looking at the infrastructure to support it. And, you know, that we have to be able to charge it. We have to have the facilities to charge these vehicles when they come, or to find devices which can do so. And in establishing the facilities, Senator Braham, we also have to be conscious of the fact that we want to do as much through renewable energy rather than using fuel to do so. So I am only just rising to say that everything has to be put in a perspective, and that it would be most useful if we understand and appreciate exactly where we are going in that regard, if it pleases you.
Thank you. Thank you very much, Mr. President. And I will simply say at this point that this is a type of context within which, I mean, we are on the same page. We are all agreed that infrastructure, training, understanding, and a shared vision are critical for us to make sure that we're delivering the changes that we want to in terms of environmental protection, climate action, and of course, the efficiencies that are brought for different types of use, including electric vehicles. And in this context, I want to, in sharing a program underway, also express appreciation to the government of the German Republic for the support which they are currently providing by way of a program that is assisting in the transitioning of the public fleet from gas to electric mobility, e-mobility program, the training that they're giving from a mechanical perspective in that regard, because you have to be able to support the vehicles as well, and then of course the provision of a certain number of buses which will come in due course. So we are not only working within trying to increase the appetite here by moving the tax levers or the duty levers that we know are, can act as an incentive. But we are ensuring that, yes, charging infrastructure, and we are working with JPS on that as well, and have been for some time, that is increasing the charging infrastructure that exists, as well as looking at how, again, we move the public fleet, as well as providing this framework that will allow private citizens to take better benefit, or rather to use the benefit to increase use of electric vehicles. So, Mr. President, with that, I do seek affirmation of the resolution before us.
Thank you very much, Minister. Thank you very much, Minister. The question is that the motion be approved. Those in favor? Against? Normally we would have taken a break here, but I'm not going to do so on the off chance that we may be completed before the staff of the House die of starvation.
Yes.
Thank you very much. Minister Samuda.
Mr. President, I now move for the suspension of the standing orders to enable me to take a second reading of the bill, shortly entitled the Electronic Transactions Amendment Act 2023, and to take it through all its concluding stages.
Thank you very much, Minister. Members would have heard the question. Those in favor? Aye. Against?
Mr. President, the matter for consideration of the Senate is the Electronic Transaction Amendment Bill 2023. This bill was brought before the House of Representatives and passed without amendments on March 28, 2023. It is noted that a printing error was identified in the House, which has been since rectified in the bill distributed. Mr. President, the government of Jamaica has a foundational principle of its work and efforts: the modernization of all aspects of society where appropriate. The proposed amendments to the Electronic Transactions Act is one of the ways that the government is ensuring that the enabling environment exists that would ensure the maximization of operational efficiencies and improve productivity levels in the island's courts through the use of technology. Mr. President, there are aspects of the country's existing legislative framework that preclude the automatic rollout of advanced operational processes that are commonplace features in any modernized justice system. A foundational activity in support of this push to increase efficiency, Mr. President, would be the utilization of electronic signatures as a means of authenticating warrants generated electronically in the justice system, and the recognition of electronic documents and records as records of the court. The court system, Mr. President, in Jamaica is currently highly paper-based, and adjustments are required legislatively to facilitate the acceptance and use of electronic records in the court system. Mr. President, the Honorable Minister Delroy Chuck, in relaying key statistics from a report on traffic courts, noted that over 70% of total annual caseload in the court system is comprised of traffic matters, with the vast majority of those cases requiring the issuance of a warrant. Mr. President, in the context of the existing process used in the courts to generate warrants and the vast number of cases for which warrants are outstanding, there is need to swiftly revise the process for the generation of warrants to allow for greater expedition. The ability for judges to utilize an electronic signature in the issuance of warrants would greatly improve productivity in this area. Mr. President, it should be noted that between February 1, 2023 and March 27, 2023, 66,428 tickets have been issued for violations of the Road Traffic Act 2018 and Regulations 2022. Of this number, payment was made for 27,617 at the various tax collectorates across the island. 246 were settled in the courts, and 5,511 will likely require the issuance of warrants in the short term. Mr. President, when taken in the context of the fact that the remaining 5,511 will likely require the issuance of warrants in the short term. Mr. President, when taken in the context of the fact that the remaining 33,054 matters generated over the last 55 days have still not been brought before the courts, along with the approximately 981,921 unpaid tickets issued up to January 31, 2023, the monumental task facing the court, if reliance is placed on warrants issued by handwriting, cannot be discounted. Mr. President, the amendments to the Electronic Transactions Act will facilitate the utilization of available technologies that will assist in ameliorating the already overburdened conditions in the island's courts through more efficient use of resources, as there will be less reliance on a highly paper-based process. Mr. President, Jamaica will not be reinventing the wheel, as this more streamlined and paperless approach to the management of documents in the court system is currently being utilized in multiple jurisdictions, such as the United States, Rwanda, Scotland. The use of electronic signatures that are securely affixed serve as a digitized image of the handwritten signature are approved in these jurisdictions by the court and governed by legislation. Mr. President, documents signed via this means by a judge carry the same force and effect as if the signature was imprinted by hand on a paper copy by the judge and can be executed as needed. During a transitional period, Mr. President, warrants will still be generated and printed. However, we want motorists to be aware that they may have outstanding warrants if they do not pay the traffic fines within the prescribed time and take the necessary steps to address same. Mr. President, the end game is increased productivity in the island's court system through the utilization of more efficient operational processes. Where this is done without compromising the safeguards that currently obtain to buttress the process governing the issuance of warrants, this will redound to the benefit of the court's internal and external stakeholders. Mr. President, the ability to trust the integrity of the system facilitating the use of electronic signatures is key to the success of the proposed operational process changes, and specific defense mechanisms will be introduced to thwart attempts by unauthorized persons to access and abuse the system. The maintenance of the requisite security measures to protect the infrastructure supporting the electronic signatures from fraud and other nefarious intent will be paramount and will, Mr. President, be mitigated through the establishment and maintenance of a stable and controlled environment supported by the requisite safeguards and fit-for-purpose infrastructure, as well as the training of the users interacting directly with the system. These efforts will increase the levels of trust and acceptance in this process by stakeholders in the justice system. Mr. President, it is with all this in mind that I commit this bill, which seeks to amend the Electronic Transaction Act and consequently amend the Justices of the Peace Jurisdiction Act to the Senate for its approval. Mr. President, I will highlight the main features of the bill. At Clause 1, the clause sets out the short title and the construction of the bill. At Clause 2, Mr. President proposes an amendment to Section 6 of the Principal Act to make it abundantly clear that no provision of the Act or any other law shall be construed as precluding a court from giving, receiving, or keeping any document, record, or other information in electronic form. This will, however, be subject to the rules of the court and provisions of the first schedule of the Act. Clause 3. Mr. President, this clause provides the amendment to the first schedule to include circumstances in which the Electronic Transaction Act could apply to court proceedings or procedures. This is where the civil procedure rules or rules of the court made pursuant to any law specifically expressly provides for its application. The clause also provides that Section 7.1c, 8.1d, 10.1d, which require consent of the recipient, will not apply to a warrant or document issued by a court or record or other information kept by the court. Clause 4, Mr. President, consequentially amends the Justice of the Peace Jurisdiction Act in respect of the terminology used in reference to the issuing of warrants so that the terminology is compatible with the language used in the ETA and Interpretation Act. Mr. President, this ends the clause-by-clause summary of the bill. And before I commend this bill to the members of the Senate for their approval and certainly for contribution of colleagues, I remind members of the numbers listed. It tells you that we have a chronic issue on our roads. We all know the tragic stories. There are too many to mention. Certainly throughout my lifetime I can think of many. But this seeks to bring accountability in the system and ensure that we are able to enforce the laws that we have passed. I thank you.
Minister, I take it that you noticed that there was an error in the name of the Deputy Speaker. So I understand it has been corrected. So you didn't notice it? You notice it now? Yeah, go on, good. Thank you, Senator Samuda. Senator Scott Motley.
Mr. President, when the minister was piloting this bill in the other place, he said something that struck a chord with me. He said, efficiency is doing things right. Effectiveness is doing the right things. He also went on to say that the proposed amendments to the Electronic Transactions Act is one of the ways that the government is using to maximize operational efficiencies and improve productivity levels in the island's courts through the introduction of a paperless, digitalized, and digitized system. Mr. President, Jamaica has long been talking about a digital system. Jamaica has long been talking about electronic filing. And we are impatient. It has been implemented in the Eastern Caribbean since 2016. And during COVID, it took off like lightning. I implore the minister to give life to the promises which have been made by the Chief Justice and by him, that we are going to move to this space. And Mr. President, it is clear that if we do so, we will be effective in doing the right things. Now, Mr. President, in relation to this particular matter, which is taking priority now, let me express a few concerns. Nothing will work unless the system works. You have to have a system which is efficient. And Minister Samuda, my concern is that in December, there was a litany of woes which we heard by persons who said they had already paid their tickets, but it reappeared on the system. In fact, in truth, there were people who didn't know that there was a system that you could go and look up and see if you have outstanding tickets. But with a big rush to take advantage of the matters which were being offered by the government, people discovered it. But so many people were complaining that they had already paid their ticket and it appeared. And unfortunately, unlike Senator Allen, who could go and produce her company annual report, which the company's office did not have a record of, a lot of them had lost or not taken care to put up their tickets. And my concern in the context of what we are doing is that a warrant is a very, very serious thing with immediate and significant consequences, because the right to one's liberty has been known to be one of the most important constitutional declarations. Senator Sinclair, if they don't recognize you, can you imagine if a warrant comes up on the device for a ticket you have already paid? You wouldn't get the ticket. No, okay. I'm just, no, but seriously, in a serious way. I was being flippant. I'm going to go now. I imagine and I fear that there will be circumstances when a person is presented with a warrant, an electronic warrant by a police officer, in circumstances where they had paid their ticket. You know the system. Let me just explain it to those who do not understand. So you get a ticket. You get a date. If you do not pay the ticket by a particular date, you have a court date on the ticket. If you do not attend the court, there's an automatic issuance of a warrant for your arrest. So we start with the beginning, which is that the system has to be so established that once you pay for your ticket, it is recorded and sent to the court so that the court will not issue a warrant. And I can assure you that is how it's supposed to work, but it does not work efficiently. And so I am rising today to caution that the consequences of it not working efficiently are really serious on a motorist. Indeed, I pose another scenario. I pose a scenario where the warrant is executed, but is not removed from the system, although the person is brought before the court. So that you are apprehended by a policeman, because the warrant executed on you means that you are to be taken into custody and kept in custody until you face a court. Now, when the policeman, when they're serving you a warrant in your hands, what some of the police officers actually do is tell you that there's a warrant out for you, so present yourself at the courthouse at 10 o'clock on a morning, and they will execute it at the entrance to the courtroom door so they don't have to take you into custody. With this electronic warrant, I don't know that there is any such flexibility. And so if there's a warrant and it comes up, you are supposed to be taken into custody. I know it's a production of it, you know, but I raise this because, and I remind you, Senator Sinclair, because you normally pay a lot of attention, that in the system in December, there were people who were saying they paid their tickets, but it still appeared as unpaid. So what I'm saying is that you have to ensure that the system works. Because in a case such as this, you might have a warrant executed, but it still remain on the system. Can you give me some assurances rather than just say that it can't happen? Assure me that the system which has been established is such that I need not have any fear for the motorist who has been given a ticket. I have been fortunate. I don't have any. Unlike some of the senators who are sitting to my left. I don't have any to contend with. And I'm hearing such a version that is paid right away. We will see. But no, I want the system to work. I want it to work well. I want it to work efficiently. I don't want somebody's liberty to be taken under circumstances where it ought not to. And since I'm on my feet, Mr. President, I want to speak quickly before a point of order and call upon the government to do something. You see, the monetary limits in the Parish Court Act, Senator Golding Campbell, they were amended in 2015. You can't sue for more than $1 million. Inflation has completely eroded that. And I'm taking this opportunity to ask the government, in the same way they're looking at this, to improve the efficiency of matters, look at the monetary limit in the Parish Courts Act. The Chief Justice has in fact commended the parish courts on their clearance rate. And I am saying to the government, put it at $3 million. It's not a scientific analysis on my part. The government has the resources to do the scientific analysis. But the limits have been eroded by devaluation, and it costs and causes a lot on the litigant who has to utilize the Supreme Court. So in trying to make a system efficient and effective, Senator Sinclair, I know you will join me in this call. Increase the monetary penalties. If it well, you always say that the S's agree, right? So I'm glad to hear you are supporting me in this call, if it pleases you.
Thank you very much, Senator. Thank you very much, Senator Scott Motley. Senator Sinclair.
You know, pardon me, Mr. President. I think you having too much. No, you've seen a lot. Thank you, Mr. President. Mr. President, the bill to amend the Electronic Transactions Act cannot be opposed. And the comments that have been made from our colleague across the floor would indicate that there is support for it. So, President, change is never easy, and in many instances there are efforts by some to resist. However, once implemented, I'm certain that the ease of doing business and working within the court system, we can look at it not in the commercial sense of business, but it is still business. Once it is realized, more and more persons will come on board, learning to do things electronically, and I may be speaking about myself with my limitations. It may be challenging for many. But in making the adjustments, we must ensure that everyone is taken along that journey. Because we have heard the comments, especially from out in the rural parts of Jamaica, where persons are now being forced online, but sometimes the change is so sudden. There is not much education that is taken and sensitization of persons who, in the traditional sense, they just use the paper. And they think probably using it is even more safe than going into the digital and electronic space. But that is where the world is trending, and so we all have to get on board. Mr. President, the issue of warrants have been commented on by Senator Scott Motley, and the care that one needs to apply. But even in the present system that is paper-based, I have seen situations where persons have been wronged in that regard. And I hear the concern, and we must ensure that what is put in place in respect to traffic tickets in particular, you are issued a ticket electronically, it goes into a system which is sent to various agencies, the tax office, the courts, they also have it, and the Jamaica Constabulary. And I had a discussion with the minister who has committed, Minister of National Security that is, and also the Minister of Justice, that the system that will be in place is one that will be robust and effective to ensure that you don't have the concerns which arose in the past. And we have to hold them to that, and hold all persons that will be critical to the use and application of the system, that it works effectively and efficiently, that persons are not negatively impacted. So, President, the advantages of electronic record keeping and transactions are many. The efficiency with lower costs, electronic processing is generally faster and less expensive than paper processing. In respect to recovery of documents, especially those of some vintage, is a critical and important point. Currently, Mr. President, over the past 2 weeks, I've been checking on something for someone who was convicted 20 years ago in the parish court in St. James. And 2 weeks has passed, and the file was only just retrieved. But the person who, well, yes, you say, I'm lucky. I'm lucky. There is one, Mr. President, a situation in the Supreme Court where somebody is looking for a probate that was granted many years ago. And we have gone about 3-4 years, and they can't get a copy of it. So, recovery of documents is something, a tremendous advantage that will come by virtue of us moving into that space. The storage space that is going to be saved, the freeing up of space that can be used for other things. I went into the strong room where they keep the traffic tickets in the St. James Parish Court. And what I saw there was amazing. The 4 walls had traffic tickets from the roof to the floor. And so I asked him, these tickets that I'm looking at, these are the ones that were paid over the many, many years. I said, no, sir. Those are the unpaid tickets. Those are the unpaid tickets. And we have more, yes, unpaid. Thousands and thousands of tickets. And they have more if they took me into another room. They would be able, but what I saw the court staff going through would have been much easier if we had an electronic-based system over the many years. So getting there is going to be, is very important. The distribution of documents between interested parties, plaintiffs, accused persons, defendants, is also of tremendous value, as well as the healthier environment by having less paper in the space. And we have seen our courthouses. I think Spanish Town was on fire at one time. There was one in St. Anne that was literally burned. In Manchester, we had a fire at the Manchester Court. But with moving into this particular space, the electronic space, we can have records being kept in remote places and avoid the attendant risk from fires and other disasters. Mr. President, when I look on the objects and reasons, and this is where I'm going to also join with my friend across the floor, because it says that the amendment is expected to maximize the efficiency of court processes and improve the overall experience of users of court services. And so that ending aspect of it is where I want to focus, which is the improvement of the overall experience of users of the court service. Mr. President, we need a large injection of funds into the improvement of our courts. The court buildings that we have across Jamaica, I don't think that they are fit for purpose, to be honest with you. We have done improvements, but they have been improvements in a small way. When you have persons, the judges, the witnesses, the accused persons walking in the same space, jurors who are judges of fact, we tend to disregard jurors, right? But they are judges of fact. They are as important to the system as the learned judge who sits on the bench. But you have potential witnesses, the complainants, the judges of fact, sharing the same space. When they get to court, sitting in the corridor waiting for probably the courtroom door to open, the accused person who is on bail, they potentially be sitting right beside a person who comes to court to sit as a juror. So we need to have improvements in our courts, in the buildings and how they are laid out in order to make it more effective and make the overall experience of those who have to use the courts be something that they can enjoy. Mr. President, we have passed several legislation, and in particular, the Firearms Act that speaks to minimum sentences, and I support it fully. We need to have additional gun courts. We need them so that persons, including the accused, can get their matters tried and disposed of quickly. And the victims who have to go to court and expect to receive justice, that their matters can be heard quickly and efficiently. Because, Mr. President, the delays that we are presently experiencing in relation to those who go to court, it can impact upon the administration of justice and generally just the rule of law. Some persons take matters into their own hands, Mr. President, out of frustration and a basic right of a fair trial in a reasonable period of time is recognized in a lot of instances more in the breach than in its observance. My friend also spoke about the reduction in the backlog, and the Chief Justice has been championing that. And in that regard, if we are more efficient in the courts, and if this particular legislation that we are dealing with makes the courts more efficient, and time, you have more time on your hands, especially in the parish courts, and I come from rural Jamaica, I am joining with you. I said I'm from rural Jamaica, but I'm from the city of Montego Bay.
You don't like to be called the second city?
No, we will not be called the second city. But in any event, you know, Senator Scott Motley, we tend to think alike. And probably that's why I'm probably on the wrong side, you know. But we tend to come down on the same side, especially when it comes on to certain things, and the justice system is one of them. But I am joining with you today to make a call on the Minister of Justice to increase the jurisdiction of the parish courts from the $1 million limit. And I am proposing $5 million as the limit for the parish courts. And if those, well, you applauded, so I was even going to speak of the conservative view that it should be $3 million. My personal view is that it should be increased to $5 million. Because, Mr. President, I think it is, yes, sir.
Of the 1 million moving to 3 million, what's the logic behind it? What's the logic behind keeping it at 3 million or 1 million?
No, I am saying that it should be increased to 5
million. The logic of keeping it, for example, at 1 million, that the magistrates are not competent enough to handle matters over 1 million, because they're sending people to prison for 7 years.
In fact, well, put it this way to Mr. President, as you raise it, they have the potential under several bits of legislation to impose fines of $5 million and $3 million. So if you follow that trend, then I can't see that it can be in any way difficult for the civil limits to be increased to a higher amount. So the increase, Mr. President, can easily be attained by the minister making an order which will be subject, of course, to the affirmative resolution of Parliament. You know, so it's not difficult. They had moved that into the legislation compared to what it was before. So it's something that can be done. Yes, sir? You know, Mr. President, yes, the issue as you have raised the devaluation and inflation, which makes the most minor accidents exceed the limit and persons would either have to abandon the amount in excess of the $1 million, giving up their right. They are giving up their right to something that they are entitled to because they don't want to have to journey to Kingston and go through the rigors and complexities of taking their matter to the Supreme Court. A person with a claim of $1.3 million, $1.5 million would have to go to the Supreme Court unless they're going to give up their right to the $500,000, or as the case may be. And as I said, there are the higher costs and attendant and extensive delays going to the other place. So, Mr. President, with those few comments, I support the amendment that is being made. I believe that it is taking us into the right direction. Some of us will move a little slower than others because they are coming from way back, like myself. I may be, on the out before, but I think it is going in the right direction. The advantages exceed the disadvantages, and whatever securities that have to be put in place, I'm certain that this administration, the ministers that are there, will ensure that they are there, that no one suffers as a result of an attempt to improve on the efficiency of the court system. Thank you, Mr. President.
Thank you, Senator Sinclair. Senator Brown.
Thank you, President. As Senator Scott Butler said, we are certainly supportive of this electronic signature issues. And I hope, Senator Samuda, that one set of people who will not get these warrants electronically issued is to those who carry children in public passenger vehicle. Because the government has made a commitment to bring legislation here to remove that punishment and that requirement for child seat in the child seat. So I would hope that the electronic signature and electronic warrant won't be issued for those. Because just as today, the 4 items on the agenda was done quickly, suspending the standing order, that the matter, and just as we remove, because it was in breach of the law, the 9%, I hope that the government will bring the legislation here to facilitate the policy decision which we are told has been taken, that child seats are not going to be required in the public passenger vehicles. And Senator Sinclair, as I sit here, I am expecting between now and Tuesday to see the electronic indictment being issued almost real time as anybody else in the United States. Because those who live their life not paying people made the mistake of paying one person. And then as a result of paying that one person, we will see an electronic issuing of indictment. May it please you, Mr. President, and may we get out of here very quickly.
Thank you very much, Senator Brown. Senator Samuda. Minister Samuda, I'm sorry.
Thank you, Mr. President. I thank colleagues for their contributions. Just to note, one of the reasons it has taken us this long from when the bill passed in 2018 to now to come to get to this point, to the February 1 part where the act came into effect, was the building of the system. Now, that process wasn't easy, but I think we're pretty satisfied that where we are now, there is great integrity in the system and the data. The interconnectivity between the entities is strong and significant, and you'd all be aware that there's been a lot of work and a lot of a lot of investment made in the connectivity of the varying touch points in terms of those who certainly work with the Road Traffic Act and others. So the connectivity to our courts is underway by way of the National Broadband Initiative. The connectivity of all of our collectorates is passed. And the fact that the digital machines that issue the tickets are connected to the network. And I think firstly it would be useful to pause and just, though we have been in the past, I think it's always good to acknowledge those members of staff from eGov, from the Ministry of National Security, Ministry of Justice, the Courts Administration Division. I hope I'm not forgetting anybody who pulled this system that was broken, shattered even, together. And I think it shows that when we come together, we can accomplish big things. And I think this is definitely a big thing. But best practices are being followed in ensuring that the system has the efficiency and the integrity that we all want, Senator Scott Martin. And I think that's an important point to note. We've also built significant safeguards in the system. The judge ultimately retains power and the discretion and has to be the one to instruct that his electric signature is fixed. I yield, as it is on that side today. I note the concern raised, and I see a note here indicating that the Law Reform Amendment of Penalties Act 2017 amended the Judicature Parish Court Act to increase the fine from 1 million to 3 million. So it's no. So and no, it's just it was stated at one. That's what I've been advised, that it was amended to 3 million. Mine. If it is to be corrected after, we will do so at the next sitting. But this is very clear that it was amended in 2017. And I have further information from the technical, 2019, sorry. And I have further information from the technical team at the Ministry of Justice that it is further being reviewed for contemplation of further increase from 3 million by Q3 of the upcoming fiscal year. The suit. So that's my information here. So okay. I yield to those who speak legalese, but in essence, what is before us today is a step in the right direction. It is another increment in moving us closer to efficiency in our court systems. It's another increment in ensuring that we are able to hold those to account who continue to flout our laws, not least of all the Road Traffic Act. And with that, Mr. President, I ask for a second reading of the bill.
Thank you very much, Minister Samuda. The question is that the bill be read for a second time. Those in favor? Against?
A bill entitled An Act to Amend the Electronic Transaction Act and to Provide for Connected Matters, read a second time.
The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. Thank you very much, and based on the apparent consensus, I put clauses 1, 2, 3, and 4. Those in favor? Against? Ayes have it. I put the title and enacting clause. Those in favor? Against? Ayes have it. The question is that I do report the bill as having passed committee stage without amendment. Those in favor? Against? I do report the bill as having passed committee stage without amendment. Minister?
Mr. President, I ask that the bill be read a third time.
You have heard the question. Those in favor? Against? Madam Clerk?
A bill entitled An Act to Amend the Electronic Transaction Act and to provide for connected matters, read a third time and passed.
Madam, just before you rise, I just bring to your attention, for you might not have recalled, that next week is Good Friday. Next week is Good Friday. So I will join you in wishing the staff of the House, including the Speaker, her staff, and all concerned, a happy and holy Easter.
Thank you, Mr. President. Before I join your joining me, I wish to just ask you if we could recommit announcements.
Okay, for sure. Yes, of course. The question is that the item announcements be recommitted. Those in favor? Against?
Also laid on the table of the Senate today is a copy of the report of investigation conducted into the allegations of impropriety and irregularity surrounding the award of a contract regarding the provision of quality surveying services at a property located at 4 Windsor Road, St. Anne's Bay.
Thank you very much.
Thank you, Mr. President. With that, I would wish to...
A copy of the bill to you. All right.
Thank you, Mr. President. Mr. President, I now wish to, of course, take you up on that gentle joinder to wish everyone in this Senate, our amazing supporting team who have been with us all day today. It's been quite a long one and a tough one, but we thank Hansard, we thank the clerk and her supporting team. We thank the marshal, we thank our orderlies who have ensured that we're well, we thank security who has been making sure that our surroundings are secure, and wish each and every one of them and their families a holy and peaceful Easter. And so I'm sure that, and so say all of us. Thank you. With that, Mr. President, I would ask that the Senate be adjourned for a date to be fixed.
Thank you very much. The question is that the Senate be adjourned for a date to be fixed. Those in favor? Against? This Honorable Senate now stands adjourned for a date. Every Jamaican has the right to know what is happening in Parliament, to know when new laws are being passed, and to give their opinions on legislation